VLS grad from 2004, and spent some of the best years of my life at Vermont Law School. The education that I received at VLS has really formed the foundation of my professional career, and the lessons I've learned at the old classroom building, at Oaks Hall, and on the Ultimate Frisbee field have really shaped who I am today. 2 weeks after I started at Vermont Law School, planes flew into the World Trade Towers in New York, and it was a time of, we got a little feedback here, I don't know what's going on. It was 2 weeks after September 11th, and definitely a lot of uncertainty and transition going on in the world. And you know, from that experience as a 1L student in an ever-changing world, really formed who I am and how I look at the law. But it was the great community that we established at VLS, the bonds that we struck with our friends, as well as the experience that helped through those transitions. There's a lot of uncertainty and transition going on in the world today, and we are going to see some of that. For myself, I've been involved in biofuels since I graduated, and executive orders, unofficial White House advisors, NOTAs have all put the advancement of this industry that I'm in to pretty much a standstill. It'll be great to see how folks who are in different spaces and industries have perceived the advancement of clean energy during the Trump administration. We've got 3 great panels, and we're going to be joined by former FERC Commissioner Norman Day this afternoon. We'll be taking a few breaks in between, and I encourage you to connect with as many folks as possible while you're here. If you didn't pick up one of these little panels, it'll be a great way to kind of jot down some notes for each of the speakers. Feel free to write down your notes or questions. Folks who are online can type them into the chat, and we'll try to get those out to the speakers. And that's really what I like the most about this event. It encourages a dialogue between each other, an opportunity to reconnect, share best practices, as well as learn from each other. Before we dive into things, I would like to say a few quick thank yous to folks who have made this possible. Our host here, Olson and Bird, Elise, is she in the room? Thank you very much for coordinating this and hosting us.
Glad to have everyone. Welcome.
Melissa in the back, who handles a lot of the stuff back at South Burlington in the Alumni Affairs office for us. Thank you very much for coordinating. And of course, Dr. Kevin Jones. If you don't know Dr. Jones at the IEE, definitely go say hi. Thank you, Kevin. And especially to all the distinguished VLS alumni who've given up their time and also helped create some great content. Jess Olson, Chris Pino, Thomas Ashley, James, Michael Kessler, and Mark James as well. And well, while we've seen that change and transition is also certain, it's a great pleasure that we're able to kick off this year's symposium with our new president and dean, Tom McHenry. He's the 9th president of VLS. I've just met him, and I'm excited to see where you take VLS during your tenure. For those of you who are just meeting Tom, like myself, it's not his first day at VLS. He's taught many years of the summer sessions, so thank you for that contribution. Those are definitely some of the most intriguing classes that I felt Vermont was able to offer. He's dedicated the last 30 years of his life to the field of environmental law, a journey that's taken him from Yale to NYU to Gibson and Dunn in LA to numerous nonprofits, and now back to VLS full-time. So Tom will kick us off with some opening remarks, and then we'll roll right into our first panel with Jess Wilson. So thank you. Tom?
Thanks, everybody. I'll be blessedly brief because I think you didn't come to hear about Vermont Law School, but for the ones in the room, just a few things. And if you'd like a little more, you can watch my installation video if you're suffering from insomnia, because I just got formally installed as the Dean of Vermont Law School on Friday, and Audie, my partner from Gibson Dunn, which I just left at the end of June, and Audie joined us, when did you join us?
7 months ago.
7 months ago. He's still counting months, and I'm counting months too, so we had a chance to overlap. And just helped me out because I was stuck in the lobby of our building waiting for a law partner to have breakfast with me this morning. And I think that I worked on an air project with David many years ago, doing this intern work at NRDC. I am really excited and thrilled to be the Dean and President of Vermont Law School. The reason I have such a highfalutin title, which my brothers are required to use one of those two names, is because we are a private independent law school. We are not part of the University of Vermont, for anybody who assumes that we are. And we're one of a few, I think only a little more than a dozen private law schools in the nation. And of course, all of you know us because of our strong environmental and energy programs. And one of the interesting things about energy is how, thanks to climate, although I understand that's a word you're not supposed to use in certain governmental agencies these days, but because of climate concerns, the energy issues and the environmental issues have come together. So I just want to say a few things and then turn it over, I guess, to Jess, who will take it from there. Dan, thank you for your leadership and your innovation in organizing this group, but also in just doing the whole project all together. I think Alan, where's Alan with us today? Alan, right there. Alan Strasser, class of '93, also played a very active role in that. Kevin's already been mentioned, and some of you are probably also going to go to the ELI dinner tonight, so we'll see you there. And I had a delightful time talking to someone who got a master's degree and a JD degree. I just assumed it was from Vermont, but it was from a fellow institution down in North Carolina, Duke. So there's some other people who are playing in this game. But I'm really thrilled about the wonderful, strong academic program we have at Vermont Law School. One of the most exciting and pleasant things about being dean is all the alumni you run into who are doing interesting and exciting things in the environmental and energy and agriculture arena, or just being regular lawyers, or making craft beer, or making cheese in Vermont, which we have 1 or 2 graduates who do. I'll just end with one story, which I always enjoy, that I learned when I went to the reunions in June, at the end of June. By the way, for anybody at VLS, please come to reunions because they're a lot of fun. And I was with the class of 1977, which was the second class to graduate from Vermont Law School. So they entered in 1974, which was before the law school was accredited. And this fellow was talking about how he had been bumming around Europe. At the end, he graduated from college, and a lot of people bummed around Europe, and some people did that to avoid their draft board, but he didn't mention that. But he was bumming around Europe, and he scheduled a call with his parents. Back then, a transcontinental phone call was a pretty big deal. It was expensive. And he was talking to his dad, and his dad said, "Well, I have some news for you." He said, "Well, what's the news?" He said, "Well, you've been admitted to law school." And the guy said, "Well, that's great, Dad, but I didn't apply to law school." And the dad said, "Well, I applied for you, this place up in Vermont, and you got accepted. You should have go to law school." And he thought about it for a little while, and he, I guess, had enough traveling around Europe. He came back. Law school was accredited while he was a student there. He graduated, went to New York, took the New York bar, passed, practiced law with his dad for 25 years, so the best 25 years of his life. So those are those kind of stories you hear when you're a teen that really warm your heart. And with that, I'll turn it over to Jess, and thank you all for being here, and happy to chat with you. And for any of you who are alums, I'll either see you at the LI dinner tonight, or just follow up and come visit us in South Royalton. Do not be strangers. Thank you. Jess.
Hi, welcome everyone. My name is Jessica Olson. I'm a 2007 grad of VLS and currently a partner at the Ayers Law Group with Richard Ayers, who is one of VLS's board of trustees and a co-founder of NRDC. He's a very, very special part of the running of VLS. I just want to note that our second panelist will be here.
Please enter your access code followed by the pound or hash sign.
He apologizes and he's on his way. So let's get rolling. Our first panel will discuss what's next for federal climate policy.
Thank you for calling GoToWebinar. This conference room number is no longer active. Please contact your account administrator with any questions.
Do you want me to wait? Okay. So we're going to talk about federal climate policy with an eye towards updating folks with a focus in the energy field. After 8 years of many new federal efforts aimed at reducing greenhouse gas emissions, the Trump administration is now taking action to reverse course on nearly every single one. Our panelists will provide updates on and analysis of federal climate policy developments over the last 10 or so months as agencies continue to implement executive orders on regulatory reform and energy independence, focusing on how these changes will affect the energy sector. Our terrific panelists will cover all you need to know in about 75 minutes. So we'll give each speaker about 15 minutes to offer their comments, and then give the audience and our panelists some time to engage for about 30 minutes. With that, let me introduce our speakers. You have their bios in the handout you received at check-in, and if I read all of their credentials, we'll need about another hour to do this. So I'll just give you the basics. To my right, we have David Doniger, who has served in posts at the White House Council on Environmental Quality and EPA, and is currently director of the Climate and Clean Air Program at the Natural Resources Defense Council. We will have Jeff Homestead next to him, who's a former EPA Assistant Administrator in the Office of Air and Radiation during the George W. Bush administration, and currently a partner at the law firm of Bracewell. And at the end, we have Avi Gargos, certainly last but not least, former EPA General Counsel for 4 years during the latter part of the Obama administration, and now co-chair of the Environmental Litigation and Mass Tort Practice Group at Gibson Dunn. David, you're up.
Thanks, Jess, and thanks all of you for coming. We're in a very weird time. I've likened it to a geologic era, a very short one, I hope, called the Trumpocene. Maximum of 4 years. And it is a time period in which government policy from the top down is radically divorced from science, from our public health and climate protection needs, from rational energy policy, from markets. And there's so much to talk about. I wanted to focus on the executive order from March 28th, which is the main one that attempts to set in motion the review, and now it's supposed to be review and potential revision, but it all looks like repeal of various climate-related regulations at EPA, the Interior Department, some others, reversals of previous executive branch policies. And then take you through one complete litigation that's occurred so far, and almost like a detour, but it's a hopeful detour. And then come back to the Clean Power Plan. So the new administrator of the EPA was picked because he is a long-time opponent of the EPA and its mission, and he's acting his part. A lot of questions were raised in his confirmation hearing. There's some very interesting answers she gave on climate science. Tried to say as little as possible, but there's one very interesting response to a question from Senator Merkley asking if he accepted certain basic obvious tenets of the Intergovernmental Panel on Climate Change science reports, and he responded by allying himself with 4 of the discredited skeptical notions, like that there's been no temperature increase in the last decade, or, well, I won't go through them all, but it was very revealing because it shows where he's listening to what he's prepared to say. He didn't do very much until March 28th, when the president finally produced the executive order that purports to set in motion the reversal of all these things. One of the first things he did pursuant to that executive order was to suspend some regulations for methane emissions from the oil and gas system, which were in effect, but the most important requirements of which were about to come into effect June 2nd, this past summer. And the oil and gas industry asked him to yank these rules out of effect. And he did, citing a provision of the Clean Air Act that allows for the agency to reconsider rules. They would have the authority to reconsider rules even if they didn't have that specific provision. But it also says that when the conditions are present so that a reconsideration is required, then you have the discretion to suspend the rule for 3 months. And he said we want to suspend it for 3 months in preface to a longer suspension, 2 years, and preface ultimately to a repeal. Well, the conditions you have to show to trigger that provision is that there was a defect in the prior rulemaking, so that something really critical to the outcome hadn't been noticed. There'd been a failure of notice, or there had been a turn in the final rule that couldn't have been anticipated, and someone was deprived of a meaningful opportunity to comment. NRDC and a group of other environmental groups and public health groups sued him on the same day that he issued the suspension. And in record time, 30 days, we got a merits decision from the DC Circuit overturning the suspension. The court agreed with us that none of the identified issues that were supposedly the basis for failures, notice failures and failures of opportunity to comment, none of them was bona fide. All of them were, in fact, issues that could have been raised and that were raised. So the statutory predicate for yanking the rules out of effect without notice and comment or any justification on the merits was not there. They were not there. The court ordered the rule back into effect, and that's where things remain with the oil and gas methane rule. Right now, although we believe that there are still efforts afoot to develop a proposal to repeal or revise it, this is one of a number of cases that have been brought by NRDC and others, some of them outside the environmental sphere, challenging these peremptory decisions with no process, and by and large we're winning, either because the courts rule that is a violation of the Administrative Procedure Act, or because the agencies give up and withdraw their peremptory action. So that's one point on the board for the principle that the government has to follow the rules, the administrative law rules, even as it changes policy. And that means you have to have proposals which are grounded in law, fact, science, and then public hearings and public comment periods, and a final decision and an opportunity for judicial review. Well, so that brings me to really the main event, which is the Clean Power Plan. The Clean Power Plan was established in the last administration because power plants are the biggest, or maybe not the second biggest, cause of carbon dioxide emissions from the United States, along with motor vehicles, which EPA had also regulated in the last term, the last administration. The Clean Power Plan set targets under Section 111D of the Clean Air Act for states to adopt plans to reduce the carbon pollution from the power generating sources in the states. Why is it being done state by state? Well, there are parts of the Clean Air Act that allow EPA to regulate the power sector directly, such as for acid rain or for hazardous air pollutants. There are other sections of the Clean Air Act which authorize regulation of the power plant for other dangerous pollutants, but through a process that at least gives the states the first option to participate in the process by writing a state plan, and then gives EPA the job to regulate the power plants directly if the states don't participate or don't have an adequate plan. So this is the provision. This provision is the one that would address carbon, and it does follow that state plan model. The targets were different for each state depending on the power mix, and basically require the same level of effort in terms of pollution reduction from coal plants, no matter where they were located, gas plants, no matter where they were located, and then gave both the sources and the states enormous amounts of flexibility as to how they might choose to meet those emission reduction limits for the coal or the gas plants. I'm not going to go into great detail, but in his time as Attorney General for Oklahoma, Scott Pruitt thought this was contrary to law, and now he's taking his views and putting them forward in a new proposal that was published on Monday to repeal the Clean Power Plan. And partly because of the victory in the oil and gas methane case and others, we re-emphasized the administrative law basics that you have to change a rule the same way you made the rule. You have to tear the buildings down the same way you built them up. So the proposal doesn't actually lift the Clean Power Plan, it proposes to do so. And there'll be a public hearing and a public comment period that runs out December 15th. That's the current schedule. Although EPA is talking about doing all kinds of supplementary analyses that will take another 6 months, after which they say they'll allow for additional comment. So we may be on, still maybe on a fairly slow timeline. The principal issue is whether, and I'm not going to get technical on here, I'm going to get conceptual on it, is whether EPA is required to treat every plant as an individual island and limit the measures that plant can be expected to do to stuff that can fully accomplish all by itself without any credits from actions taken elsewhere, or whether, as EPA assumed and reported in the last administration, the power sector should be thought about differently because the plants aren't islands. They haven't been islands for 125 years since the days of Thomas Edison. They're now connected together in the grid. They dispatch power in an interconnected way. When the price of one fuel goes up, the use of the plants using that fuel goes down, and the use of the plants using other fuels goes up. Energy efficiency is in the mix as well. Renewable power is in the mix. And the power system, the realities of the power system are that no coal plant is an island. So can EPA write a rule, interpret the law and write a rule pretending that it is, and pretending that the plants aren't connected, repudiating the view for the last 30 years that in light of all those connections, an emissions trading system that connects, that links together their compliance approaches is perfectly acceptable and appropriate way to design the rule, and then that the emission control level should reflect what can be done through this interconnected grid with this interconnected emissions crediting system at a reasonable cost. There is a requirement to consider costs, and there's also a requirement to do as much as you can to reduce the dangerous pollution within the constraint of a reasonable cost. But can you design the regulation in so clumsy and unrealistic a way as to be able to throw up your hands and say, there's really nothing that can be done, maybe other than tuning up these plants for the efficiency of the way they burn the coal. There's really nothing else that can be done to reduce the emissions, so we're going to set the standard at some trivial reduction level. Remember, the Clean Power Plan called for a 32% reduction from the peak levels of 2005 to be achieved by 2030. It turns out that the marketplace is moving faster in the adoption of gas and renewables and efficiency than even EPA assumed in 2015 when we set the rule. So this turns out not to be that demanding a target. Some people then say, well, so what do you need a Clean Power Plan for? And my answer to that is the purpose of having a Clean Air Act is to deal with dangerous pollution that the marketplace doesn't curb on its own. So the very idea is that your clean air regulations should be going some distance beyond where the marketplace will take the industry on its own. Again, the marketplace is reflecting the realities of the interconnected grid, the choices of power generation and power conservation that each company has, and the way the real world works. So our comments are going to be far more technical than that, from a legal point of view, but that's the basic thing. And we'll see whether, assuming that it really makes this decision finally, what the courts will make of it. I think the courts, he's going to have a hard time showing that his options are as limited as he says they are. I guess I should say one more word. I'm using up Jeff's time. I'm sure he would agree with me. Jeff always says, I'm sure David would agree with me. And we really do. But yesterday, NRDC, the other environmental allies, and also the supported state attorneys general filed a response to the proposal, really to the status report about the proposal, that the EPA had filed with the court. The EPA is saying, don't decide the case concerning the Clean Power Plan. It was argued more than a year ago, but don't decide it. Put it on ice indefinitely until we finish this new rulemaking, which we have no deadlines for. They're also saying we might be considering a replacement, but we haven't even put out an advance notice of the replacement. So, but court, don't do anything. And we responded that the court ought to decide that case because the proposal itself shows that the agency is not on track to fulfill its duty under the Clean Air Act, under the Massachusetts case, under other cases, to solve this problem, to respond to the climate problem and the contribution of power plants to it. At a minimum, the court should keep the EPA on a shorter leash and decide, period by period, whether to extend the abeyance. But it should not give the EPA the blank check to continue to do nothing for an indefinite period. So that's the main event. There's lots of other things that you could talk about and you could ask questions about. There's a parallel proposal by the Energy Department to the FERC to basically to write, to rig the market, to write rules to subsidize coal and nuclear plants, which are losing in the marketplace. And that we sometimes call the two proposals together the dirty power plant. And we'll see how they go. Thanks.
Thanks, David. Maybe Jeff just wanted to be sure you got the last word. Oh, here we go. Right on cue, my friend.
Jeff, I've just been saying that. I'm sure you would agree with that.
And Jess, I'm sorry, we're having problems with the connection, so we're going to call in one more time. so you won't
Okay.
hear that sound.
We'll take a pause when we hear all
right,
this.
thank you.
Speaking. We'll give Jeff a minute to acclimate himself to the panel.
Please enter your access code followed by the pound or hash sign. To enable audio controls, please enter your audio PIN followed by the pound or hash sign. If you do not have a PIN, just press pound or hash. Welcome to the webinar. You have entered as an organizer and may now speak to any other organizers or panelists on the line. When you are ready to begin the presentation, press *1 to allow all attendees. The broad
Are we good, Melissa?
You're all set.
Okay, and I'll just remind everyone too that this event is off the record. So as you think about questions and as our panelists answer questions, you can take some comfort in knowing that you will not be pulled to the green wire tomorrow. Jeff?
Thank you. With that bit of encouragement, I'll be candid. First, I apologize. I've been looking forward to this. I thank Jessica for inviting me. And I will say, although I don't always agree with David and Audie, I always am very interested in what they have to say. So I'm sorry I missed the initial presentation. But I suspect
Well, let me start again.
I suspect we'll have a lively discussion. As probably everyone in this audience knows, this administration has a different view of climate change and climate change regulations. And as a legal matter, it's been interesting to see how they are going about changing the regulatory framework that had been created by Audie and his colleagues under the Obama administration. I've certainly been on record as saying that I think several of the things that they did, and most notably the Clean Power Plan, exceeded EPA's authority under the Clean Air Act. So I am probably the one person up here who believes that the Clean Power Plan should be revoked, and that if it does find its way into court, it should be struck down as being well beyond EPA statutory powers. So far, I will say from my perspective, it's been a little disappointing to see how the administration has approached this task. And I think part of that has to do with the fact that they've taken so very long to get people at EPA who really understand these issues or have any experience about EPA. As is the case with any administration, it takes a bit of time to get people in place. But ordinarily, the administrator, as was the case here, is confirmed very quickly, and that he or she is given a fair number of political appointees that can start right away, that can begin working with the staff on some of these issues. They have some very fine people, some very smart people, but they didn't really bring anybody on board who had any experience with this set of issues. Literally, I think of all the early appointments, there was maybe one person who had a couple of years working on the Hill on Clean Air Act issues, and no one who had ever been at EPA. And as a result, we've seen that, notwithstanding a lot of announcements, very little has actually been done. Some of you may say that's a good thing. For those of us who believe in regulatory reform, it's been a bit frustrating. And so now, 9 months into the administration, we finally have a proposed rule to repeal the Clean Power Plan. It's actually a very short proposed rule. There's no reason to understand. It's hard to understand why it would have possibly taken this long to get to this point, but at least we finally had publication of a proposed rule on Monday. And surprising to many people, including me, that proposal makes it clear that EPA has not decided whether it's going to do a rule to replace the Clean Power Plan. And this is, I say surprising, because I would say that virtually everyone in the business community believes that it's important that they do a replacement rule. There's certainly much discussion of what that would look like, but I think there's general agreement that that EPA has a legal obligation to do a replacement rule, that they don't necessarily have a specific deadline, but it's been a surprise that after 9 months, they are publicly saying that they are still not sure if they're going to do a replacement rule. And I do think that puts them in a difficult position legally. The other question is what purpose is served by this advance notice of proposed rulemaking that they have said they are going to do. And again, in my mind, it's a little bit embarrassing that after 9 months, they're saying, we have no idea what we're going to do. You know, we haven't decided whether we're going to issue a replacement rule, and if so, what it would look like, and please send us your ideas. It does look like, and I think this is something that's been speculated, that maybe the administrator is, for whatever reasons, interested in kind of kicking the can down the road as opposed to actually moving forward with a legal process. So maybe I've been too candid in expressing my frustrations. I may get in trouble with the administration that I purport to support on these issues.
Remember, Greenwayer's not here.
The other thing that and I'd really be curious to hear what David and Audie think. I suspect that both of you probably talked about the filings that were made with the DC Circuit, asking the DC Circuit to go ahead and resolve the legal issues. I suspect we may have more opportunities to talk about that, but that certainly would be unprecedented. I can't think of a case where an agency has proposed to repeal a rule, and then the courts go ahead and rule on the legality of the rule that they're proposing to repeal. I'm quite confident that has never happened, at least in the DC Circuit. However, we've already had a couple of surprises from the courts on this issue, and I don't think it's impossible. And I mean, again, I think if that were to happen, you might actually get a motion to the Supreme Court asking them to vacate the decision, because it really would be an unprecedented step. But I think the announcement about the ANPR makes that even more likely, if they're essentially telling the court, you know, we propose to repeal this, but we have no idea what we're going to do after that. I think that can be used as an invitation for the court to rule on a case that's been well briefed and well argued. So I'm not predicting that's going to happen. I would say it's still a very low likelihood, but I don't think it's impossible that we would get a decision from the DC Circuit, and given the makeup of the DC Circuit and the way the oral argument went, we could get a decision from the DC Circuit saying that something is legal that the administration has recently proposed is not legal. That certainly doesn't prevent the administration from revoking the Clean Power Plan, but it certainly changes the legal dynamic and puts the administration in a much more difficult position. So I think and those are the things that I had been prepared to talk about, unless there's other things that you want me to. I mean, there may have been some discussion about the new source rule.
No, not yet. I was going to ask
but
that later.
Then I will not address anything else beyond that. The only other thing that I will say is we are in an unusual situation where the vast majority of the business community appears to be to the left of the administration. And we've seen that on a number of rules. And I think, you know, the Clean Power Plan is one example. Even a better example may be the standards for cars and light-duty trucks, the so-called CAFE standard, or CAFE standard plus EPA's carbon regulation, where the White House seemed to relish the idea of changing those standards and challenging California to a duel over the waiver authority, and you had the auto manufacturers quietly in public but very insistently in private saying that's not what they wanted. They really wanted the midterm evaluation to be reopened so that some of the lingering issues could be addressed, but the auto companies don't necessarily want the uncertainty that would go along with litigation over the Clean Air Act waiver. And so on that issue, I think the administration has, I won't say back down, but I think that they've seen the wisdom of the position taken by the auto companies. And as a result, they're no longer talking about jumping in and revoking the California waiver. I don't think that's off the table, but I think there is some hope that there will be some accommodation from California and from the auto companies. And the auto companies, and again, I don't represent any of them, but they appear to be interested not in necessarily a rolling back, but in more compliance flexibilities and the way certain credits and other things are handled. So that's another interesting example. And the third I would point is the new source methane rules for new oil and gas operations. Again, my impression there is most people in the industry believe that there should be rules in place, and they have concerns with one or two of the specific requirements in the Obama methane rules, but they are not looking to have those rules revoked. They're looking for some meaningful, but not major revisions to those standards. So I think ultimately some version of the CAFE standards, maybe with some more compliance flexibility, will remain in place. I think we will still have methane regulations in place, at least EPA regulations for new oil and gas operations. And then I think the question's open on what happens with the Clean Power Plan. And some of us are hopeful that they will actually develop a rule that comports with Section 111D, with Section 111 of the Clean Air Act. And from a policy perspective, and David has heard me say this before, one of the reasons I think that's important is because I think if EPA simply carries out its statutory responsibilities, it will be apparent that the Clean Air Act is not a very good framework for regulating CO2 emissions, and it kind of puts the issue back where it should be, which is in the United States Congress. And I actually think that by doing that, if EPA and the courts make it clear what the scope of EPA's authority is, it makes it much more likely that there could be some sort of a negotiation that would lead to meaningful legislation. So thank you very much for your time, and I really do apologize for missing your presentation.
Thanks, Jeff.
So I get to
You're in luck.
I'm going to revise it totally. It's nice to be here. I do appreciate the invitation, and nice to be with both Jeff and David. What I thought would be useful is to dial us back about 2 to 3 years, because I think the three of us, if we could agree on something, might agree that the present situation in terms of the administration and its kind of fitful steps to repeal and to look at reconsidering a slew of rules is at the very least messy and presenting some uncertainties for all. And so there's a reason, I think, even beyond who is in the administration, for why it feels so messy at times. And if you take a step back 2 to 3 years, back in 2015, certainly 2016, and this goes back to my time as general counsel at the agency. The agency knows it's got 2 years left in the second term of the Obama administration. We had a lot of important rulemakings underway, Clean Power Plan among them, but certainly not the only one. We talked about the methane NSPS. Ozone was underway, mercury and air toxic standards, Clean Water Rule, a lot to get done. And I think everybody, and this is not kind of a D or an R thing, everybody understands that do your work early. And so the idea was these rules, to the extent we could get through the processes, would birth, so to speak, primarily in 2015, and if things needed to carry into 2016, the administration was certainly on the watch and we would do them. What is a bit of a truism nowadays, I don't think it was always this way in environmental law, is that there's kind of such poles when it comes to evaluating and assessing what the agency does. So the vast majority of rules that I think are consequential coming out of an agency like EPA end up being challenged in court. And so it's not a surprise, it wasn't a surprise for many of us that the rules that we finalized in 2015 and 2016 would, in the main, be litigated in the DC Circuit and elsewhere around the country. Those cases begun to be litigated. You then have issues about impending compliance deadlines. Parties not kind of typical in terms of litigation strategy. A lot of times the regulated community will seek to hold the matter in abeyance or move to get some relief, if you will, from compliance deadlines. That's not, by the way, the norm, and so certainly the agency a year or two ago, in most instances, wanted to ensure that so long as companies could comply, that they were abiding by the compliance schedule set forth in the regulations while the matters got litigated. Again, didn't happen in every case, but it happened in many. But as we got towards, I think, the end of a term, not surprisingly, there was a great deal of focus on the litigation calendar. And so to the extent that you could conclude a case while the last administration was in place, there was a general belief that would be certainly better for the prior administration, cleaner in many respects, present a bit of a cleaner slate for the incoming administration, whoever it might be. But that's not something that was, of course, within the control of the government at all instances. And I remember quite well the thinking, rightly or wrongly, that as parties were negotiating briefing schedules, there was a lot of back and forth, and you can imagine there was some strategic interest to get briefs later in time to perhaps bridge November of 2016, and there was desires perhaps on the other side to get things done sooner. It shook out, I think, differently in a variety of ways, but that has a role in where we are today. And if you think about the Clean Power Plan in particular, that was argued, many of us were there in September, en banc hearing, argued in September, not, of course, decided. And here we are, don't have a decision from the DC Circuit. I mean, you think about what was in play there that created that delay. DC Circuit on its own, perhaps wisely, decided to have an en banc hearing right away. Some people might suggest that that created itself delays. It's very much harder, of course, to get an opinion out of 10 judges than a panel of 3. The pending nomination of Judge Merrick Garland, who then had to recuse himself from that proceeding. And all of a sudden, leadership, if you will, the chief judge in the DC Circuit, on one of these rare instances where there's an en banc, is missing. Kind of, again, people might speculate, did that have an impact on the timing? At this point, it's a bit water under the bridge, but I mention these sorts of things because it kind of carries us into what the new administration inherited in January of this year, which was for the vast majority of the major rulemakings, including the energy ones that we're talking about today, they were, for the most part, in litigation with compliance deadlines coming up. Now, Clean Power Plan, of course, stayed. The implementation was stayed pending completion of judicial review by the Supreme Court. So that's a little bit different. But in all the other instances, the new administration comes in and says, look, we're new on the block. As Jeff said, very few nominees were in the door, and so Scott Pruitt and some of his kind of close advisors are probably sitting around in the early part of the administration saying, look, the president has just told us to take a hard look through this executive order and figure out what our position is. And so you can go literally case by case and see kind of serial filing after serial filing where the administration goes to the courts and says, look, one of two things. Either, boy, we don't know what we want to do here. We just showed up, we haven't had a chance to review it, we don't have our people in place, which I thought was an interesting argument given that they hadn't even nominated people in many of those instances. But we need time to figure out what we want to do, or in some instances, they'd actually early on made decisions to go about a reconsideration process, and so they could go in those filings to the courts and say, look, we do know one thing, which is we do want to reconsider this aspect or that aspect of the rulemaking. And for the most part, you know, the courts held those matters in abeyance. But they held the litigation in abeyance. And so then the quandary is, well, what do we do about these imminent or kind of upcoming compliance deadlines? You know, how do we go about a stay for that? And that's why I want to talk a little bit about process. When I got to the agency, and I spent the last term of the Obama administration as the general counsel, first term as the deputy general counsel, the notion that a new administration with new ideas is going to look back and figure out what the last one did and figure out if they want to have changes, that is not new. Now, we haven't had a party-to-party, you know, kind of change since Ronald Reagan to Bush 1, so it's been a while, but the notion that, again, the new team shows up and they want to at least understand what the last administration did and reconsider some things is not new. And in fact, the environmental statutes, irrespective of the change in administration, are already replete with mandates to do periodic reviews and in effect, reconsiderations of sorts to see whether technological advancements, you know, or other health studies have suggested that prior standards are no longer warranted or appropriate. But in order to do that review, and David said it well, if you want to walk out a door, it's got to be the same door you open to get inside in the first place. And that's where I think this administration struggled a little bit early on. EPA has got renowned media experts, air experts, water experts, toxic experts, and by the way, some of the best in my judgment, lawyers in those fields, air lawyers, water lawyers, etc. And a lot of times I find the people that go into agencies and political positions are themselves well-versed in those sorts of media. You know, they've come up in whatever setting, studying air, you know, water, waste, etc. You will never, well, I should never say never. It's rare that you will find somebody put in position who is an expert on the Administrative Procedure Act. It's that statute in law school that you can't figure out why it's important. It sounds so dry, but you show up to the agency and you realize, at least I did, it's the key to the kingdom. And in many ways, because that is where I think administrations get tripped up the most. That's where, if you do it wrong, you create delays and uncertainty, perhaps unintended. But that's exactly, I think, what this administration fell into a little at the outset. So David, you know, mentioned what happened in the methane rule, right? They came in, they knew they wanted to look at some reconsideration issues. They attempted to use a provision under the Clean Air Act, 307D, where it talks about reconsideration, as though that, you know, was one required, and then because of that, there was some discretion to do a 90-day stay. They needed that space, by the way, in order to go through a separate APA notice and comment rulemaking to actually, again, go out the door the same way you went in. Use notice and comment if that's how you got your compliance deadlines, and that's why everything is required. That's what's required to make a change in the regulation. So to get that time, they used this Clean Air Act tool. DC Circuit, in a fairly scathing July opinion, struck it down, said you can't use that. More recently, 2 weeks ago, another really interesting case came down in the Northern District of California. This dealt with the Bureau of Land Management's rule on methane in federal lands. And there too, there was an upcoming compliance deadline, clear that the Department of Interior and BLM are going to relook at it. And so there's a provision under the APA, Section 705, that basically says when justice so requires, you can postpone an effective date pending judicial review. So the administration comes in and says, well, we're going to postpone the compliance date for the upcoming deadline, while we kind of get our ducks in a row and go through a notice and comment proposal to really extend things and reconsider things. In a fairly, I thought, well-reasoned opinion of the Northern District of California, the court says, well, two things. One, compliance dates are different than effective dates. Okay, you can't conflate the two, and so that particular provision was designed while you've got a court case, but before something has gone into effect, you can kind of stay the effective date, not a compliance date, which is part of the final promulgated regulation. For me, the more interesting portion of the decision, and we'll kind of see how this plays out, was really a discussion or an allusion to the when justice so requires portion of that provision. And there the court said, well, that really must mean that you kind of looked at all aspects of the problem here and determined that justice requires that you do the following. The complainants, if you will, and it may have been NRDC, I'm not even sure, were basically saying, look, BLM, in justifying their attempt to stay the compliance states, only looked at the cost to industry of complying, didn't look to either the benefits of the rule or, if you will, perhaps the other side of that cost equation if things are delayed. And you really need to look at both sides of that issue if you're going to have, I think, a fuller analysis and justify the invocation of that stay provision, even if you were going to use it before the effective date. So those are two examples, not the only ones, by the way. There was another issue with ozone designations as well, where the administration, I think, kind of tripped over itself a little bit process-wise, trying to figure out how do we get out of the conundrum of having inherited all these rules that we may or may not like. Many of them are in litigation. Many of them have ongoing compliance deadlines. But we've got these APA requirements that are going to take up time and, again, perhaps themselves create some uncertainty for companies about whether they should or should not make the investments to comply in the meantime. So one of my takeaways, I guess, early on in kind of observing things is that the administration would do well to pay a little bit more attention to its procedural advisors and allow them to at least provide a bit more of a secure pathway to accommodate whatever reconsiderations that they want. And we and the administration will kind of face this as well with all the procedural hurdles that they're going to have to go through with respect to the Clean Power Plan. Let me just, if I can, switch gears just a little bit on the Clean Power Plan, and then I know there's a lot just to kind of talk to and have all of us engage in a little bit more of a discussion. One of the interesting things to me about what the administration has kind of proposed to do is they said, look, we think a different legal interpretation is appropriate. As Jeff said, the argument is that the agency in its Clean Power Plan exceeded its statutory authority. It wasn't so much that the record was mixed or didn't support this or that. It was really that the law doesn't permit it. Agencies are entitled, of course, to change positions. They're entitled to change legal interpretations on things from administration to administration. They just have to provide a reasoned explanation for it. here, the one kind of tricky thing that I think everybody's going to be contending with is the Clean Power Plan was anomalous in the following respect. One, because it was 1,500 pages or however long it was incredibly complex and long. As part of the technical support documents, and not every rule has got a TSD package or needs one, this was one of those rare instances where there was a lawyer's memo, a legal memorandum that was, if you will, part of the technical support document compendium. So you've got 150 pages of legal explanation supporting the Clean Power Plan as to why the decisions were made, talking about the uniqueness of this particular industry and its interconnectedness. And again, what was behind the legal interpretation. So it's not to say, again, that legal interpretations can't change, or for that matter, that this administration going through its process may not itself be successful in whatever it's aiming to do. But it has an additional public hurdle, if you will, I think, that these sorts of things don't have elsewhere, given the transparency with which I think the prior administration was on its legal rationale behind its interpretations. I'll stop there.
Thanks, Audie, and thanks, Jeff and David, for those very insightful remarks. I'm going to kick it off with a question and then open it up to the audience. We haven't talked a lot about the new source performance standards for power plants, and I just wonder, my recollection is that the Unified Agenda said that that rule would be repealed but not replaced. If that is the case, what then happens to, does that make it all the more certain that we actually will not have a replacement for the Clean Power Plan? Do you think that's perhaps could be part of the forthcoming justification to not replace the Clean Power Plan?
Again, I think that three of us will probably agree that because of the endangerment finding, they do have a legal obligation to have a 111D rule to regulate CO2 emissions from new fossil fuel power plants. I think the reason it has not gotten so much attention is because the only kinds of new power plants that people are building are gas plants and renewables. And when EPA did set CO2 emission limits for gas plants, but those were set in the traditional way where EPA looked at what the current technology is achieving, and they established standards that do ensure that new combined cycle natural gas turbines reflect sort of the current state-of-the-art technology. So people who are building new combined cycle natural gas turbines can meet the NSPS standards. It's not costless, but they are reasonable and realistic. So no one who's actually building power plants is unduly constrained by that regulation. The problem with that was the determination that for coal-fired power plants, that carbon capture and sequestration had been actually demonstrated. Again, I think that both legally and technically that's hard to justify. But since no one's building new coal plants, it's not actually having any immediate impact on anyone. And I think that's the reason why it just hasn't gotten that much attention. I wonder whether they're even going to get to that, just because they have so many other things on their plate. They still don't have their team in place. Again, I'm beating a broken drum, I guess, but they have other things that are probably higher priorities. And so I don't think it's impossible that we would get through this first term, perhaps only term, and still have that rule in place, just because it hasn't risen to the top of the list. And that would effectively enshrine the current system where no one can build a new coal-fired power plant, because with that regulation, it's not even close.
I don't think it's worth spending a lot of time on, but I don't think we agree on whether, on the last statement, that no one could build a new coal-fired power plant. So I believe people can build a new coal-fired power plant. If the market demand were there, they could build it with carbon capture and storage. But I think it would not be the best use of my time.
Audie, do you have any comment on that?
I don't have anything to add.
Okay. Okay. Any questions from the audience? Melissa says we have 8 minutes. Please state your name and your affiliation, please, and wait for our microphone.
I'm Michael Kessler. I'm with the MISO, the Midtown Independence and Small Creek. I'm just curious if the administration wanted to go back and reevaluate the endangerment finding itself, what would be the process that they would have to undertake to engage in that kind of reevaluation?
I took the first shot at that. There are petitions pending to do that from groups that are pretty far out there. And far out there in a different direction. And my view is there's a Mount Everest of science that supports the endangerment finding, and it would take a double Mount Everest, or at least a bigger mountain, or at least a mountain to try to undo it. And the science just isn't there. The people who are behind these petitions live in a bubble and delude themselves. There's actually a very interesting memo that was published in E&E News today from Joseph Bass, who runs the Heartland Institute. And it's just such fascinating reading. I'm not even going to summarize it, but you should read it because he's just in an alternate universe. And I think Scott Pruitt knows that this would be a fool's errand. And it would take an enormous amount of effort. It would have no credibility, and it would lose in court. The red team, blue team exercise, I don't quite understand what that is, except as an attempt to engage some public confusion. Some confusion of the public on the science. It's not the appropriate process, and it doesn't even link into an endangerment proceeding as far as
Let me, I guess, just add a couple of points. One, Competitive Enterprise Institute, one of the organizations to which David's referring. CEI, literally yesterday I saw, sent a letter into Administrator Pruitt referencing the petitions and concluding by asking for a meeting to discuss their petitions to undo the endangerment finding. So I don't think it's crazy to think that there will soon be at least discussions about it. I very much agree with David's assessment that it's a Herculean task, given the peer-reviewed science there, to go about a process to undo it. The other thing, of course, is that the endangerment finding is the foundation for, in essence, federal regulation, CO2, particularly under 111. We've already seen that the government kind of beat back with the Supreme Court attempts by some in the AEP v. Connecticut case to use kind of common law and other sorts of public or private nuisance claims to address CO2. And the rationale was because we already have a framework for federal regulation coming out of the Clean Air Act, again, all of which I think is premised in part out of the utility of 111 stemming from the endangerment finding. I think one of the greater concerns that would animate this administration, I would suggest should animate this administration, is that if you undo or seek to undo the endangerment finding, you essentially, to a greater extent than already exists now, I think, invite courts and others into the field of CO2 controls. And in many ways, I can't imagine that itself is in service, for sure, of the industrial stakeholders.
I'm sure that's one of the reasons why there's, if you're right, Jeff, unanimity that there should be a replacement rule. in the utility industry, at least some of them, believe that they would be exposed in the way that Audie just described if the Clean Air Act were moved.
I think we have time for just one more question. Evan?
Hi, thank you. I'm Evan Mulholland. I work for the State of New Hampshire Environmental Services. It's really for Audie. You mentioned that you think that let's see, how should I phrase it, that the administration has made missteps in the Administrative Procedure Act. I mean, it doesn't make any sense to me. I mean, there's enough experts on the Administrative Procedure Act. There's enough people you can go to help out to get your agency to do a notice and comment, to do a repeal. I mean, the APA allows that, all the case law allows that. So isn't it possible that they're sort of doing that on purpose? That the goal is delay? Just wait and wait and wait and wait? I mean, why, you've got a delay in the court, you're delaying it by not doing anything, why act? I mean, maybe that's on purpose.
Actually, can I answer that question? I'll let you answer too, since I didn't get to talk about the endangered anyway. So remember, the things that they've lost are attempts to delay regulation. So they don't really gain anything by playing the lose here, right? I mean, there's no strategic reason for them not to want these rules to be upheld. My impression is this is not the first administration to come in with some distrust of EPA staff, and I think that was true even at the beginning of the last administration. And you know, the feeling was all those people who had been complicit with the Bush administration, can we really trust them to help us implement our agenda? And I think the same thing happened here. And so I think what happened is some of those decisions were made without talking to the people who could have helped them. And I will say this, and I suspect Audie would agree, the vast majority of people at EPA are really true civil servants in the best sense of the word, and they believe that their job is to do their best to implement the decisions made by their political leadership. And I think most people at EPA will work just as hard for the Trump administration as they did for the Obama administration, although maybe not with quite the same, maybe their heart's not in it. But if they had
the
used,
era of overtime is over.
If they had actually worked with the career staff in Audie's old office, they would have avoided some of these missteps. But I really don't think that they did.
Yeah, I agree. There's not a lack of expertise at the agency. It's got some of the foremost experts on these administrative issues. I firmly believe that it was a lack of consultation, a rush to judgment, so to speak, as to what they wanted to do. And by the way, I don't believe that Administrator Pruitt likes to lose, honestly. And I say that because I don't buy into the notion that that there's this strategic play here to kind of lose and delay. You know, as Jeff said, you can win. You know, you can win and delay too. That was never the equation. So I view this as a failure to take advantage of the kind of civil servants that are at the agency and have advice to offer.
David, Jeff, Audie, thank you so much for your time. I think I'm not the only one in the room who wouldn't mind spending another few hours chewing over these issues and discussing them. But thank you very much for being here today. That was a really fun panel.
Transmission. I'm with MISO, the old Midwest ISO, as are several of the panelists here. We manage the transmission grid in the Midwest. Hold on. I'm also learning how to use technology. So there's a saying, especially out in corn country, that if you build it, they will come. That may work for imaginary ballparks, but unfortunately that is not the case for renewables or storage or any of the technologies that are needed to drive our energy future forward. What you need in order to make those technologies possible is a robust transmission grid that can take those resources from wherever the wind is or wherever the sun shines to where that power needs to be consumed. So when we talk about planning for renewables, and when we talk about trends in terms of energy policy, a necessary component of that conversation has to be, what are the effects on the transmission system? How is this going to be planned? And how is it possible to distribute all of this energy? So there are a few trends that I wanted to point out that are going on in MISO now in the Midwest, which may or may not be reflective of elsewhere in the country. And that is, if you note now, we have a marked decrease in the number of new gas and oil plants and coal plants. We are coming to near the retirement age for many of these generation resources. And this is happening largely for economic reasons. We are also seeing a very large number of renewable generators being brought online or being attempted to be brought online now. Currently, MISO's generation fleet, over 13% of it is renewable, and that is expected to grow. Currently, we have over 58.8 gigawatts being studied for interconnection to our system. And the question then really becomes, if that's where we are right now, where are we going? And I think that's the big open question given policy uncertainty, economic trends. Is a move towards increasing renewable penetration inevitable? Is it something that that needs to be planned for or needs to be managed? And what is the role of our regional transmission organizations in making this happen? Those are some of the fundamental questions that our panelists today are going to answer. When you think about what goes into building transmission, there's a tremendous number of drivers that determine what gets built, when it gets built, or how it gets built. There also is new uncertainty that has been added. For example, with our latest policy, what does it mean to have a resilient grid? I've heard viewpoints on that ranging everywhere from that means that we subsidize coal and nuclear plants more. I've heard arguments, well, distributed generation is about as resilient as you get because you can knock out 3/4 of the transmission system and everyone will have power. So the main points that I want you to consider during each of the panelists' presentations are, where are we going and what is it going to take from a transmission planning standpoint to get there? With that, I wanted to introduce our first panelist, which is Michael Kessler, who is Managing Assistant General Counsel of MISO and has tremendous experience working with energy markets and can speak to both some of the drivers and some of our current trends and a little bit about where it is that we think we're going to be headed.
Thank you, Chris, and thank you all for being here today. I think I'm probably one of the oldest Vermont Law School graduates in the room, having graduated in the class of 1980. And following those early days of Vermont Law School, I was very fortunate to be actually inspired by our MD, Tom Debevoise, to start my career in the electric utility industry right in the early days of the very beginnings of the competitive power industry. With the implementation of what was the Public Utility Regulatory Policies Act, that was really the first step in initiating competition of renewables and energy efficiency resources into what was then and continues to be in many respects a very heavily regulated electric utility industry. But that was what I think of as sort of the camel's nose under the tent to the competitive power industry that we see today in many regions across the country. And this is a slide that Chris already brought up. It sort of shows you where the regions where there are regional transmission organizations or that are providing competitive markets and integrated transmission planning. can see there's a big gap out toward the west. Actually, that part of the country is starting to fill in now with some new markets that are being brought into the western part of the country. The south really sort of remains the only part of the country that is still very much a vertically integrated market for utilities with primarily Southern Company and some of the Duke Energy and other companies in Florida. But I want to talk today a little bit about how, for those of you that aren't very familiar, how RTOs, what we do, and then talk a little bit about some of the measures that Chris has already identified for how renewable energy is being integrated into our markets, some of the factors that are affecting those efforts, sort of what our market design looks like that accommodates those kind of resources, and some of the trends that we discussed this morning about where that may be going in the future. I think the earlier panel referred to a DOE initiative that was sent over to FERC just last month that was published in the Federal Register just a couple of weeks ago. We spent the last 2 days, Chris and I know Kevin was there as well, Kevin Jones, where this DOE proposal was the subject of virtually every panel discussion over the course of 2 days and what it may mean for the industry and for our markets. And so I want to touch on that again as well. So MISO here is the area in the blue part of the country. We operate markets across 15 states from Canada to the Gulf of Mexico and do transmission planning and operate our physical and financial markets for energy. We also provide reliability services across the region, and we also provide reliability services up in the Canadian province of Manitoba. So it's a fairly extensive and diverse footprint that we operate in. You can see the numbers up in the top right-hand corner in terms of the amount of people served and how much transmission and generation is in our market. We're the second, I think we're still the largest geographic market in the country and the second largest in terms of overall generation and load, the largest being that purple area, PJM. So even though it's smaller, it's a much more densely populated region that it's serving in terms of people. So what does an RTO do? As I mentioned briefly already, we provide independent transmission system access. So transmission now is open access across the country. All utility and non-utility providers should have access to the high voltage transmission system on a non-discriminatory basis. We provide reliability services across our footprint to help ensure that the grid is operating reliably. It's a topic I'll come back to when we talk about renewable energy integration, what that means for grid reliability and what some of the issues associated with that are these days. We provide regional transmission planning services, as Chris mentioned. How is transmission going to be built? Where is it most efficient to relieve constraints or congestion on the system? Where is it needed for reliability? And where may it be needed to serve public policy goals? And we also operate markets for the sale of electricity, both on a financial basis and a physical basis for utility and non-utility providers. So it's a pretty complex integrated system. MISO itself is a nonprofit, so we operate, and we're a 501c4. We operate for public benefit. We're a public service corporation in effect. We don't own any assets, but we are the grid operator on behalf of our transmission members and other market participants. I'm not going to spend a lot of time on this slide. It just shows you the history of MISO's development back in really in late 1990s when we implemented our transmission service, our markets. I think the important part of this slide really is on the right-hand side that shows starting in sort of the brown box on the right side of both boxes, the Clean Power Plan, changes in environmental policy, and then sort of looking forward, what are we going to be doing, how are our markets changing, how are the services that we're providing going to be changing in the future. We did do a lot of planning at the about the Clean Power Plan and how we would integrate dispatch, economic dispatch of units, taking into account carbon issues across our footprint. We work with a lot of states on that issue. A lot of that now has been, I would say, suspended and sort of put it on the shelf as we continue to sort of evaluate where the Clean Power Plan is going. And maybe later we can talk about some of the other markets that are trying to price carbon into the market and some of the difficulties that they're facing, challenges, I should say, that they're facing, particularly in California and New York, as opposed to making out-of-market payments for carbon. So it's a big issue in the utility industry right now as well. This just sort of provides an overview of the value. I put this slide up really just to be illustrative. I'm going to kind of throw a lot of pictures at you. I don't want to try to get into details unless there's questions, but I kind of show some of them to you really just to emphasize a couple of points. And the thing here, in addition to all of the wonderful colors that you see across the country, this by region, it's showing you different fuel mix that are utilized in the different markets across the country. So you can see the black in particular is coal, current amount of coal generation in different regions around the country. You can see in New York and New England, virtually no coal is being burned right now for electric power generation. In the Midwest, our region and that of our neighbor, the Southwest Power Pool, you can see there's an extensive amount of coal that's still in the fuel mix. Even in the Mid-Atlantic, there's still a fair amount of coal. And so that causes different challenges for different regions in meeting environmental goals and in determining how our dispatch of the system may change as different types of fuels start integrating. And I'll have a number of slides later to emphasize what Chris pointed out in terms of what our fuel mix is changing to or projected to change to in the future, even notwithstanding the fact that the CPP is sort of on the shelf right now. I'd also note, in addition to different fuel mixes, we also are subject to very different regulatory structures across the United States. The whole East Coast is primarily, except for the South region, is primarily a deregulated market. Generation and transmission have been, the utilities have divested themselves for the most part of their generation and transmission and distribution, and so they operate in a very different regulatory environment than we do in the Midwest, where most of the utilities are still subject to state cost of service-based regulation, and so our market design and mechanisms reflect those differences in the way that we work with our stakeholders, particularly with our states in the Midwest, is very different than what you might see in some other regions around the country. Forces of change impacting the utility industry right now. This is sort of the key topic that I want to talk about, and again, I'll throw a bunch of slides at you to sort of illustrate what is going on here. But the utility industry that I think until probably 20 years ago maybe was very heavily regulated, monopoly, utilities were integrated, generation, transmission, distribution, they served their customer base, they got their cost of service and return on equity provided to them by their states. They worked with each other, but until the implementation of regional transmission organizations in the late 1990s and early 2000s, it's when really sort of markets began to emerge and the utilities began operating on a different basis in terms of having, as I mentioned, transmission provided so that power could move more freely and on an open access basis. And markets provided an opportunity for utilities to buy and sell power under a system where the operator engaged in a least cost dispatch of generation across the entire system. But there's still a lot of challenges that are facing the utility industry today. And I tried to identify some of them here. Starting on the top right, cyber security is a huge risk in the industry today, as is the physical risk to the system, the need for additional resiliency that the DOE proposal is trying to address. What does resiliency mean? We have to operate a reliable system, and we ensure reliability every day, in fact every 4 seconds, as we're sending signals out to our generating units about where we want them to be and how much output is needed to meet load. But then the question is, what happens if you run out of fuel? What happens if the control room goes down? What happens if there's severe weather events? What happens if fuel can't get to the plants? How quick is it going to take to recover? What kind of increased risk are we seeing to the system, particularly as we look at the bottom kind of changes and challenges that are facing the industry now in terms of evolving technologies. We're moving away from the central coal-fired power stations to a utility system that's looking more at distributed energy. We're seeing increased coal and decreases in coal, but increases in natural gas, increases in renewables, increases in distributed energy resource. Behind the meter, rooftop solar, electric vehicles. I don't think I know that the utility industry has never been in a time of change that has been as dramatic as what we're looking at right now. And it's the most capital-intensive industry in the world. Change comes slowly. Building a new transmission line, can take 10 years, 12 years, 15 years. Building a new power plant, at least of the traditional type, can take 5, 7, 8 years or more. So as you're looking forward at these changes, the reaction time is very slow, potentially, but we're all in the industry now trying to adapt to these new challenges that are identified here, in addition to environmental changes and energy policy, which is not being driven by the federal government, but continues to be driven by the states and consumers. Consumer choice now, as much as anything, is starting to change what the face of the electric utility industry looks like. So what does that mean in MISO? What are some of these challenges? And a lot of these are the same across the country, some are different. We still have renewable portfolio standards in existence. Many states have been reevaluating those standards. Some have actually increased the standards since they were first published in the early 2000s. Others, have been looking to reduce the standards, but notwithstanding the state mandates, we'll see that renewable integration is far outpacing even what the state mandates have been. Touched on this, we see our fleet coal is projected to start. This is load growth. So, the amount of energy that customers use traditionally was back in the 60s and 70s was actually, you could take a ruler, the planners that were planning what the system would look like used to joke that they could put a ruler on a piece of paper and say 7% load growth a year, and then we'll just plan our power plants out for that. And nowadays, that's no longer true with energy efficiency measures, even with increased use of electricity through electrification of many of the gadgets that we all carry around and use. Load growth is actually flat or declining. So how do you plan for what you need to build when you have an environment where usage is actually going down, and how do you sort of time what your needs are in terms of power plants to accommodate that? As was talked about a little bit earlier, I think even though the CPD has not been put in place, there are still state mandates, and just as a result of economics, We're seeing coal starting to come off of the system, and so CO2 emissions across the utility industry are starting to decline significantly. Chris already showed this slide in terms of coal unit retirements. That's also driving a lot of the CO2 reductions, and again, we can see just sort of across the region, this graph shows where those retirements are starting to are happening under different scenarios, and even some of the older natural gas and oil-fired units are starting to come off of the system as well. And so sort of by summary of what the system looks like right now, again, illustrative, you can see going back to the early 2000s here, the base load capacity, which tended to be coal and nuclear power plants, was a fairly significant portion, represented primarily by the black bars of what was being built and what was coming off of the system. And as you look across, even up until today, you can see the amount of coal and gas, old inefficient gas units that are retiring, and you can see with the blue and the green and the that little bit of gray on top, some of which is solar, the amount of new capacity that's coming onto the system is primarily gas, wind, and we're starting to see utility solar integrating into our markets. Again, just showing a complicated chart, just kind of showing that gas is actually fairly readily available in the Midwest, and so that's starting to fuel a lot of the gas-fired power plants. Yesterday at the EVA Energy Bar Association conference, one of the folks from MIT that was doing the wrap-up was talking about how much gas is being introduced into the system, natural gas is being introduced into the system as a result of fracking across the United States. And putting aside some of the environmental issues associated with fracking, he said that in Pennsylvania alone, the amount of new gas that has been introduced into the system from the reserves in Pennsylvania would make Pennsylvania, the state of Pennsylvania, the third largest natural gas producer in the world. So cheap, abundant natural gas is what's driving a lot of growth, particularly in the Midwest and in the Mid-Atlantic region. The Northeast has some unique problems associated with gas, but that's what's driving a lot of the prices going down in the market. That's what's driving out a lot of coal in the market, because it's just not cost effective anymore to build a coal plant compared to the cost of natural gas, and as we'll see, even compared to the cost of wind and solar, are getting to the point on utility scale where they are more cost effective than building a coal plant. So our reliance on natural gas is going up significantly. It's increased, as you can see here, from 18% to 27% of our generation. In fact, it's even a little bit higher now, and it's right about, we're right about the tipping point where coal and natural gas are about the same amount of output. Coal's on its way down, gas is on its way up. In addition, we have a significant amount of wind in the Midwest already. We're in one of the most wind-rich parts of the country. Wind represents now about 12 or 13%, I think, of our total generation in MISO. And so with the cost going down, wind is increasingly integrated into our markets. And as Chris showed on that, looking forward slide, there's a huge amount of wind that's in our queue, waiting to see whether it can interconnect into the system and be integrated into the system in the future. But with the growth of all that wind, it's an intermittent resource. It blows at night primarily and isn't available during the day. Solar is available during the day, doesn't work so well at night. Energy storage, just not there yet from a cost perspective yet. So that causes some very interesting challenges in terms of operating our system. Again, the slide that Chris showed, just showing really the bar on the far right, how much wind and solar is in our queue already. It's close to 40 gigawatts on a 130 gigawatt system. with no load growth. So what does that mean? Even with coal retirements, how is that much renewable intermittent energy going to be integrated into the grid? And what does it mean in terms of operations? Again, sort of more information. If these slides are available, you can take a closer look at it. It's just showing, and Arash will be talking about this a little bit more as we look at our planning processes. What do we see under different scenarios in the future? How do we plan for this amount of intermittent wind coming into the system? So that kind of brings me to the point where the questions start to come up now. More questions start to come up. We can see that baseload retirements, coal coming off of the system, more and more coal coming out of the system. We rely on those units to provide that baseload level of generation to meet our day-to-day needs. Very reliable. Generally, and coal and nuclear units are the things that are running kind of 24/7 to provide those baseload needs. As more of them are coming off of the system, being displaced by gas and intermittence, how are we going to maintain system reliability? What's the system going to look like? What's going to replace those aging coal-fired units? Similar question, kind of the flip side of the question is bringing a lot of intermittent resources onto the system. Again, you can see the projected growth of intermittence on the system year over year from 2016, year projected out to the early 2020s. What does that mean as more intermittent fuel is on the system? We've already implemented certain measures in our market to try and accommodate that. We require wind now to provide us with forecasts of what their output will be, but you can only forecast you can only forecast how much is going to come off. You can't forecast when the wind is going to blow more. So we have certain measures in place for wind and now for solar with a small amount of utility scale solar that's starting to come on, that's come on our system already. Give us some forecasts so that we know looking forward across the day as we're going to dispatch our system, how much can we expect will be on the system so that we can maintain reliability sort of in real time. We've integrated a whole new region starting in late 2013. We just added about a third as much generation and load to our system from the south part of our region, Louisiana, Mississippi, Arkansas, and a little bit of Texas. They have very different system dynamics in the south region than we do across our traditional northern part of the MISO region. More gas is on the system, more opportunity for solar down there, but we also have constraints that limit our operation between the south and the north. So what does that mean going forward, and what's that going to look like? So as we started thinking about these questions, we started through our stakeholder process to evaluate a bunch of issues. And this process now is just sort of beginning in a rush, and talk a little bit more about what it looks like going forward. But the questions include, reliability. How do we ensure day-to-day reliability with increased intermittent resources on the system with a changing fleet, and with more loads sort of going behind the meter so that we don't actually see it necessarily. It's not available to our system, but it can change what the requirements are on the wholesale system. What new products might we need to integrate into our market to take those factors into consideration and make sure that the system is operating reliably? Are there limits? Are there certain points that we're going to hit where we go from 10% to 30% or to 50% or to 70% renewables, where it's going to require different changes in terms of how we operate the system to maintain reliability? What part of our systems are going to be affected first, and most importantly, is the south going to be different than the northern region? What kind of resources can we expect, and can they be dispatched across the entire system? And then how do we educate our stakeholders to understand these challenges that we're facing? So we initiated this renewable integration impact assessment. It's ongoing now. It's going to try and address all of those issues and probably more that I talked about. And as, again, Raj will probably talk to when we talk about it in the panel, where are those inflection points where the integration of renewables makes the most difference, and how do we address those? So with that, I will let the other panel members step up, and then I hope to be able to talk a little bit about the DOE rulemaking during the question and answer session. So thank you all very much.
Thank you very much, Michael. It was incredibly informative, especially learning about the numerous ways in which just responding to existing trends will require changes in the system, even more, not just as much as driving those trends going forward. So there's a lot of sensitivities and variables to consider. I hope to get some good questions for you after. Next up, I wanted to introduce Arash Ghazi. Arash is an engineer with MISO for more than 10 years. He's been working with transmission, with resource interconnection planning, and figuring out exactly how all of these various resources are going to come onto the system and what changes need to be implemented in order to make that happen. He has probably one of the more both bird's eye and yet granular level views of current developments in resource integration. So come on up, Arash.
Good afternoon, everyone. First made it sound like I have all the answers, but I don't. Maybe a little bit of I guess, history. MISO is unique in its geographic location, being located kind of in the center of the world. I like to call it between the Southwest Power Pool and PJM, and really we are very well interconnected with both the eastern and the western seas. Going back to approximately 10 years ago, we were at the same situation where we had policy mandates calling for renewable energy on the system. MISO states came together, stakeholders sat at the table, discussions happened on transmission development because states had renewable portfolio standards. It took over 6 to 7 years to develop transmission plans. Right around 2011, a portfolio of 17 projects with approximately $6.5 billion in cost was approved. We were looking forward to the Clean Power Plan, and that's really, it's still on our radar. Maybe from a magnitude standpoint, it's not happening as fast, but we see it happening. As both Chris and Mike alluded to earlier, economics of the system is going to play a big role. We're seeing aging fleet across the footprints and even in the neighboring footprints. Coal is retiring. When you have to compete with quick startup units, combined cycles, combustion turbines, even nuclear doesn't really have an opportunity to compete with it. So when we look at the really the interconnection queue, generation interconnection queue within MISO and even the neighbors, over the last year we've seen a significant amount of renewable energy coming into the footprint. Approximately 32 gigawatt of wind and 8 to 9 gigawatt of solar kind of distributed across the MISO footprint. We look at the neighbors, Southwest Power Pool, they have wind bottleneck in their footprint looking for transmission to get it on. So, you know, we look at it from a bigger picture. We see challenges that are taking place today with the new administration. We also run into challenges in our work too. Really one of the main challenges that we see when you try to look for transmission development is cost allocation. It's easy to say that let's look forward, or let's focus on renewable energy, location of wind or solar, but at the same time we also have to focus on how are we going to transfer the generation from, you know, location A to location B, and the challenge comes into who's going to pay for transmission. So we have challenges at our level. Certainly the decisions that get made at the higher levels do impact us down the road, but you know, we continue to push through the various processes. Look at really the planning process that we have, which is future-based planning, and by that I mean we look at the various uncertainties or scenarios that would have impact on the system and try to develop the least cost transmission plan to address the system needs. But really, I would say that, you know, the more we look at the system today, the more there's demand for renewable energy. We are seeing close to 8 to 9 gigawatts of solar coming in the south footprint. And when you really look at the portfolio mix within MISO, north is heavily, you know, focused on wind and other generations such as you know, the mixture of coal and nuclear. South is mostly gas driven. Maybe not as much appetite for wind, but they are seeing more and more of that taking place, and, you know, directions are changing. So we have hope. We were looking at, you know, studies. I know Mike mentioned the renewable integration study, which is really focusing on what we're seeing today in the generation interconnection queue, and really evaluating what we need to do in the next 5, 10, 15-year-old time frame, which essentially brings us back to early 2000s, where we developed the portfolio of projects given the federal and the policy mandates that we have. Mike, I don't know if you want to touch more on things, but I'm more than happy to take questions.
Take questions at the end.
Thank you.
Thank you, Raj. Thank you, Raj. That was also extremely informative. It gives a little bit more information about, you know, the kinds of things that we're seeing come onto the system and how we're going to be responding to that. The last person on our panel I wanted to introduce is Mr. Dennis Howe. Denny is the Director of Regulatory Policy at Avangrid, and has a tremendous amount of experience in more of the private sector, more of an outside an RTO perspective on developments.
Good afternoon, everyone. My name is Denny Hope. I'm the Director of Regulatory Policy for Avangrid, and it's my pleasure to be here at South Carolina. I've been with the company for about 6 months now. I started back in April, so I'm still fairly new to the company. But I just wanted to give a quick overview of Avangrid. So Avangrid, the company was established in December of 2015 with the merger of Iberdrola USA and UNL Holdings. We have essentially two core lines of business. We have our distribution company business, regulated the Audie Networks companies, and we have our Audie renewables. So with the distribution companies, we have 8 of those, and they are focused, are located in the Northeast, in New York, Connecticut, Massachusetts, and Maine. And on the renewable side, we have about 6 gigawatts of renewable generation, and we have facilities or operations in about 27 states. So instead of a slideshow, I brought a video today that I'm hoping I can play. Now this video, well, should back up. So Olson is 81% owned by Iberdrola, the Spanish utility. And over the past year or two, Iberdrola has been working on a program to formalize and articulate the company's regulatory policy. The main goal, the main driver for this was to let all of its employees know, what the company stands for. And so so they made like a series of 6 videos, and they also have reports in long form on these subjects. But I brought the energy markets video with me today.
We all want a cleaner world, and most countries are clearly committed to renewable energy on an enduring and widespread basis. Iberdrola, as the world leader in...
It's going to be loud. Should I turn it down?
Yeah. Can I ask you, are they all electric utilities?
I'm sorry, sir?
The utilities that your company owns, they all electric?
Natural gas and electric.
Gas and electric. Just curious.
You can try it now, Denny.
Okay.
Sorry ahead of time.
No.
Indenergy, that has been investing in renewables for 15 years and continues to do so, advocates an energy sector that supports these technologies. The wholesale price of energy, as is the case in other liberalised markets, is determined by supply and demand. In the electricity sector, there is a daily market, where generators submit their offers to produce energy in each of the next 24 hours to meet demand. Competition between generators causes them to submit their lowest possible offers. If the offer is too high, it will be another generator that sells its energy. Offers will generally be set at a level that at least covers variable costs, such as fuel. But what happens in the daily market when the penetration of renewable power plants increases? The fuels for these technologies are wind and sun, whose cost is zero, which means that they can submit offers at very low prices. When there is wind and sun, the output from renewables is high, reducing considerably the market price. Renewable electricity is the cheapest solution to climate change. That said, if the price obtained by renewables in the daily market is very low, how do they recover the initial investment in construction costs? And what happens when there is no wind or sun? For the latter situation, it is necessary to have firm plants, that is, plants that can be switched on when required. But how do these plants recover their investments if they produce for only a limited number of hours, and therefore have very low incomes in the daily market? The solution to all these challenges is to modernise the electricity market by introducing new long-term markets in addition to the existing daily market, and establishing, for both renewable and firm plants, competitive and long-term contracts with auctions for renewable plants necessary to decarbonise, auctions for firm plants to guarantee an adequate supply of electricity at all times. Without these long-term markets, it will not be possible to attract the needed investment to address climate change and maintain security of supply at the lowest cost for consumers.
So thank you very much, and I look forward to answering the questions.
Thank you, everyone. I thought we would open up the floor to questions. If anyone has, please just state your name.
Hi, Jessica Olson with the Ayers Law Group. Michael, in your presentation on the load growth chart, I wonder if you could talk a little bit about why the growth in electric vehicles was not represented.
That's a good
Forecasted.
question.
Thank you.
I think one of the answers to that question is probably that it's hard to predict, at least in our markets right now, what that growth is going to be without some kind of mandate. Some of our other fellow markets, California, they are looking at significant growth in electric vehicles. There's lots of questions about electric vehicles have the opportunity to represent not only load but generation as well. And so there's been some discussion about how would you integrate them into the grid as a source of generation. Battery storage, it could represent one of the single significant sources of energy storage as well. That presents a lot of technical complications. So I think as the industry, the vehicle industry matures and we start seeing additional growth, that will be reflected in our forecast, but I just don't think that, at least in the Midwest, it's there yet in any significant way that sort of offsets declines from other efficiency measures.
Mike, if I may add, so we do actually account for some magnitude of electric vehicles in the load growth, but when you look at the projection and compare to, say, industrial growth, it's not really as much in the Midwest with respect to, say, West Coast. But it certainly is there. There are discussions, taking place at the state commissions. Again, it comes back to what's the appetite for now, and it's not fully there. It's not mature yet.
Hold on. Wait one second.
You go good enough already.
Yes, I'm Tom Rebush with the law firm of Duncan Weinberg and Pembroke. And for Tom's benefit, I'm a proud graduate of the University of Wisconsin Law School. But I have a question for Dennis. And could you comment on New York's carbon pricing perspective, the proposal there, and how does that match with the slide or the movie you just showed?
Sure, that's a really good question. So as a lot of you know, a few weeks ago, New York State rolled out a proposal to start pricing carbon in its Olson bucket. They have sort of like a preliminary idea on how they want to do this, but I think there's still a lot of details left to be hashed out. Right now, my company is certainly watching those developments, and I think in general we would be in favor of having a carbon price in the wholesale market for sure. And as far as how it relates to the video, I would say I guess we have another video on carbon pricing, and the company, like I said, generally does support that. I don't think we have any specific company proposals in mind at this time. I think with what's going on in New York with reforming the energy vision, there's a lot on our plate up in New York. There are these pilot programs and advanced metering initiatives going on up there. So our New York folks are really busy. And I think that the carbon pricing proposal is something that we are really interested in. And going back, I guess, a few months to the FERC state policies and wholesale markets tech conference proceeding, we submitted some comments, or Avangrid submitted comments in that proceeding. And one of the things we highlighted was with respect to trying to integrate state policies such as carbon pricing into a wholesale market, we thought that a single state ISO would be the ideal forum for that, and we said so in our comments. So I think that we're encouraged by it. We're still watching it. I don't know what the outcome will be. I'm sure there'll be a lot of work for us going forward. But it's interesting, and there's certainly New York's going to be taking the lead on that.
Yeah, I would add too. It's California is integrating carbon pricing into their market as well, and there's two ways to address the cost of carbon through a market. One is through sort of an out-of-market tax or payment that's required that is that certain generators just have to add on, but it doesn't get reflected in the market price, but they're still responsible for paying per ton of output, for example, tax on carbon. In California now and proposed in New York, they're looking at integrating that cost of carbon into the market structure. And I know Brattle Group has actually done an analysis of that. And one of the two of the interesting things I think that were sort of associated with that was, one, they assumed a $40 per ton cost of carbon that was going to be included in the market. And when they sort of look at what the cost of consumers would be of including that in the market price, at the end of the day, they found out that it was sort of a wash in the final cost of consumers, because as you may have seen the study, you may be very familiar, much more familiar with it than I am, but I thought that was one of the interests, because you start to displace certain other higher cost units, and you start pushing down the cost of dispatching, least cost dispatch of units to the point where it's kind of a wash when you add that price in. The other interesting dynamic that people in the industry are trying to figure out is, how do you deal with your neighbors? So California has carbon mandates in their market, but they have resources that are selling in from outside their market. And so there's this so-called leakage problem about how you sort of integrate the costs of carbon across the border from facilities outside of your system, and it starts to get very complicated quickly when you have states that are not part of, subject to carbon pricing, that are participating in markets where there is carbon pricing. So I think there's a lot of analysis going on. That was actually the subject of some other forums that I've been had the opportunity to listen to, and it made my head spin when you start looking at the math behind figuring out how this is all going to work. So, interesting.
Hi, Evan Mulholland from New Hampshire. I was wondering if any of the Midwest states have time of use rates and if they've been successful in changing demand patterns. Having
repeat the question.
Time of use retail rates or commercial retail rates that may help buffer the renewable problem.
Yeah, that's I'm not sure. I know Illinois may. So all of our states are regulated, continue to be regulated states, except for 14 of our 13.9%, 13.9 of our 15 states are still regulated. So the utilities in there, still operate under a traditional, regulated structure. Illinois is a deregulated state where, so there is competition. There's a small part of Michigan that also operates with competition. We have an increasing amount of demand response now participating in our market, mostly in our capacity markets, as opposed to the amount of demand response that can participate in the energy markets is still very small, but they are getting paid a capacity payment to stand by and be available to operate during emergencies. The FERC has required, Federal Energy Regulatory Commission has required that states authorize entities to aggregate load in order to participate in the wholesale markets. And very few, maybe one or two, I think, of our states only have authorized so-called ARCs, aggregators of retail customers, to participate in our market. So again, we're starting to see the penetration of retail load participating in our markets. So-called load modifying resources have actually been called upon recently when we've had some severe weather events and other generation has been out to be participating in our market. So it's a trend, and it's one that we're studying closely in terms of pricing and so forth, but state policies will drive a lot of that and the attractiveness of that. And again, in the Midwest, I think we sort of lag behind our eastern and western market brethren and sisters in seeing how quickly those develop. So still waiting to get there.
Check out Vermont. They're doing a lot of things.
Thank you.
Yes, hello, Candace Crane. I'm a VLS graduate 16 in LLM and energy. I have a question following up on the cap and trade. How do you see this being implemented in New York and California when both participate in the cap and trade programs? And do you see it complicating any type of implementation?
That's a good question. Yeah, I'm not sure. I do see it as a complicating factor. I'm not sure how that's, again, I think that's part of the debate on their market design in those markets in terms of how they're going to accommodate that. But I don't know what the answer to that is, honestly.
It could be complicated because of that, especially in New England, participates as a regional cap and trade program.
Yeah, well, the RGGI market, again, so the regional greenhouse gas initiative in the northeastern states is a little bit different because that is an out-of-market mechanism. So at least up until now, that market operates separate from the energy from the New England as a New England market, and it even and to the extent it sort of drops down into the Mid-Atlantic PJM market. I think New York they do. So that cost is an out-of-market cost. So there's sort of a disconnect there between the RGGI cap and trade system and the organized markets there, and how that tax on greenhouse gas emissions is incorporated in the market price, as opposed to California, where they're trying to integrate that into the market. Yes.
Yes, and I would just say with New York, my understanding is they're trying to incorporate that price into the wholesale market, but also the legal aspect, which
Hello, my name is Christina Menahan, and I'm with ISS Corporate Solutions. But my question is on Puerto Rico. So I was wondering, what advice would you give to an energy utility that's trying to reconceptualize from scratch based on your experience in the Midwest?
I tell them to talk with Elon Musk. I mean, there has been, like many things, some of my political views to myself, but the Puerto Rico Electric Power Authority was in a serious state of, I won't call it disrepair, but they had significant problems with their utility system even before the hurricane. They were looking for to privatize the system down there, but they simply just didn't have the money for adequate maintenance of the system. if you were going to start from scratch, honestly, I think Elon Musk had the right idea. I mean, he got in touch with the governor of Puerto Rico, and he said, I did it in Kauai. It was only 70,000, customers or whatever, but I can do it in Puerto Rico for 3.5 million customers, and my technology scales up just as easily. And if you want to have a reliable, resilient system, as Chris talked about before, why not go to microgrids or mini grids, or integrate rooftop solar, energy storage, small distributed systems that are much less capable, much less subject to hurricanes, natural disaster, easier to maintain. The military operates their own systems here in this country on that sort of basis, and I would say if you're going to start from scratch, that would probably be the way to go. The significant investment here in the United States doesn't really sort of allow that, except in sort of discrete areas, and we're starting to see it now with more integration of rooftop solar, and we'll start to see with electric vehicles and otherwise. But if you're starting from scratch, why not go modern?
So I wanted to add on to that too a few thoughts. You can if you look at the situation that Puerto Rico is facing now, in some sense it's a lot like when Europe kind of skipped over landlines and largely went straight to cell phones, and that technology penetrated a lot sooner. While transmission is important, one of the reasons why it is so important is to move large amounts of power from centralized generators over long distances. On an island that does not have that much coal and that has to import most non-renewable resources from the mainland or elsewhere, it seems that a different kind of system might be in order. You could have networked microgrids that were to that could interact with each other and offset each other. Maybe you have more of a traditional grid around the San Juan area, but when you have so much infrastructure that has been destroyed, and the problem is both getting the power to the places it needs to be and having the fuel to produce that, the confluence of those factors tends to suggest a distributed generation type of solution as a reliability need, if anything else.
So I'll give you my engineering perspective. I think on one of the slides that Chris was presenting, you saw the picture of a tornado, and Midwest is known for tornadoes. But if we're really looking at technology, whether you have rooftop solars or 1 megawatt generator sitting in your garage, you're still at the risk of losing your load. What some of the Middle Eastern countries are looking at, given the size of those countries, underground transmission line is a huge factor. Less risk when it comes to flooding, when it comes to tornadoes. Now, that being said, there's a cost associated with that too. So you kind of factor in the cost and what are some of the risks, and I think for Puerto Rico, I think you look at those alternatives. So, but that's just pure engineering.
Afternoon, this is Sean Atkins from Olson, and thanks for being here. I think a couple of folks said they might speak to the DOE NOPR on grid resiliency. Just curious to hear what folks have to say.
So it was mentioned actually on the earlier panel, one of the initiatives that the Secretary of Energy promulgated recently was to propose that FERC initiate a rulemaking within 60 days, and if adopted, it would have given the regional transmission organizations, it was only in organized markets, so the regional transmission organizations would have been required to implement the provisions in 15 days after. And it was a proposal that would look to, it did not identify fuels specifically, fuel sources specifically, but it was intended to address resilience or resiliency, depending on your nomenclature, in the market. And it said that any facility that could maintain a 90-day supply of fuel would be eligible to receive all of its costs and a return on equity for having those characteristics. Shortly before the rule was promulgated, DOE had published a study looking at the industry that sort of broadly said, yeah, we need to look at these changing fleet issues, changing fuel issues. We don't have an immediate reliability concern, but these are the types of issues you need to look at in the future. So it was somewhat surprising that DOE, within a matter of weeks or maybe a month or two afterwards, published this requirement that FERC look at this rule. It was looking really at, as I said, so-called merchant or non-cost of service, any facility that had those characteristics that wasn't already included in cost of service rate base at the state level. And so the actual impact of the rule was to look at merchant or non-utility coal and nuclear facilities that could demonstrate that they have 90 days of fuel supply, although most coal facilities do not currently have, and it would be very expensive to maintain a 90-day fuel supply, but there were certain other driving factors behind the rule. So it caused quite a stir in the industry, which had sort of broadly been working with FERC to understand these issues of resilience and reliability, and their comments are due on the 23rd. We've been working diligently as MISO, as the RTO Council, I think across the entire industry. I'm sure you have clients that are looking at it as well. What would be the impact of this rule? Interestingly, one of the reasons for the rule, one of the driving factors in addition to the current administration's promise to help bail out coal, and one of the reasons why coal and nuclear are having a difficult time competing in the market is because of the penetration of renewables in the market already and the low cost of natural gas. So in the markets, as Benny's video demonstrated, generators get paid based on marginal costs of the units that clear in the market. And so if you have units clearing in the market at very low costs of gas or zero marginal cost of wind and solar, and sort of putting aside the subsidy issue for wind because they get the production tax credit, so they can afford to operate even at negative costs in the market, which they do at times. They actually have to pay to generate at certain times and it's economically makes sense to do that if you're getting a production tax credit of $30 and you're paying $10 or $15, it's still a good deal. But those decreasing marginal costs are pushing even coal and nuclear units out of the market. They can't recover their costs given the low costs in the market that they can recover. And so this has been a huge issue in the industry. The Federal Energy Regulatory Commission has been looking at, do we need to deal with the capacity market payments as opposed to the energy markets to make up the so-called missing money problem? How do we deal with pricing in the energy markets? There's all these price reform initiatives in the energy markets. It's a very, very complex issue, and the DOE initiative that we're responding to almost sort of throws more fuel on the fire in effect, because it would result in additional units now being subsidized, coal and nuclear, so that they are now fully covered in their costs and they're able to participate in the markets at zero or negative prices to the point where they will further exacerbate the problem of these low costs in the energy market. So as I said, during my presentation before, in 2 days of kind of uninterrupted discussions at the Energy Bar Association, this was the #1 topic of debate, is how do we deal not just with the DOE rulemaking, because I think ultimately FERC is going to say, yes, this is a problem, we need to look at it, but we need to take more time. We need to look at resilience holistically. It's not just about fuel supply, because you can have all the fuel that you want, but still not be able to move those electrons across the wires if the wires are down, for example. So what does resilience mean more broadly? How should we address the different characteristics once they're identified in the market, out of the market, sort of what does this whole pricing issue mean, and how are we going to move forward? So it just sort of adds, you can see all of these issues start building on themselves as you start looking at a dramatic change over a relatively short period of time in the characteristics of generation that are operating on the utility system right now, and how do we solve these thorny problems in time to maintain the reliability of the system.
Yeah, just maybe a quick example of that too. I mean, there are certainly scenarios today that are reflective of what we're doing to address the resiliency. Just looking at the southern part of MISO's footprint. I mean, the states such as Louisiana, Arkansas, they're due to flooding, tornadoes, transmission lines being down. The utilities within the states working with MISO, when they plan for transmission, the infrastructure that they're using, it's more robust. And by that I mean they're using metal frames rather than wood frames. You look at higher voltage infrastructure than lower voltage. Why? They're more robust when it comes to the act of Mother Nature. So there are things that we're doing. It's just putting that framework, that definition around it is important, but it's certainly a topic that's being discussed across the Eastern Interconnect. Folks look up to ISOs and RTOs for the answer, but it's certainly a brainstorming session at this point.
Yes, so I guess let me just make 2 quick points before I go into the substance. So we, obviously we have 8 regulated utilities in the Northeast, so reliability is of paramount importance to operating. And we not only see ourselves as a utility company, but also as a customer service company. We have basically, essentially 3 million electricity and natural gas customers in the Northeast, not to mention the companies that purchase or that we sell wholesale power to on the renewable side. And then we also, anytime we see a proposal coming from DOE or administrative agency or FERC, we try to assume noble intent on their part, and we try to bring an objective view to it. With that, we've been taking a look at the NOPR, and I spent the past several days working on our response, and we intend to file comments next Monday. And essentially, looking at it on its face, there's just, we ask, well, where's the evidence of the problem? I guess that's sort of where we are right now. We just don't see a resiliency problem. We don't see a reliability problem, and I'm not aware of any reliability problem on the grid right now as it stands today. So we're struggling with that. So putting aside the evidence and the problem for a second, getting to the substance of the solution itself. So we are certainly concerned that if the rule were to go into effect as it stands today, most likely older coal and nuclear units will stay on the system for an extended period of time, which means there could be less room for development of new technologies, namely wind and solar generation. And so there's the investment aspect of it. But there's also, we're also concerned about, specifically with the RTOs, the dispatch and what effect this might have on how units are dispatched by the RTOs themselves. So, you know, right now, I'm not an expert on the dispatch, but you know, I understand we use a security-constrained economic dispatch model, and that's sort of what everything is based off of, which essentially means that you know, we dispatch units based on transmission constraints, liability concerns, and low costs. So as a renewable generator, you know, we try to provide our customers with the lowest cost possible in order to dispatch our units. So that's sort of where, at this time, our concerns lie.
One just sort of footnote to that, because it goes to the reliability issue. I think almost every, if not every market in the country has a mechanism to ensure that reliability is maintained on the system, you know, not just in real time, but looking to the future. So in MISO, for example, and this is similar in I think all the other RTOs, we have something, it's called a system support resource. In other markets, it's called RMR, reliability must-run units. So if a unit is proposing to retire, they have to give us advance notice, and we're going to evaluate that unit to determine whether the retirement will cause a reliability problem. Now, reliability in that sense, I think, is limited to transmission system reliability. It's not an economic consideration, but if there is a reliability issue, we're going to require that unit to stay operational, and we're going to make sure that it recovers its cost of being operational until a mechanism can be put in place to address the reliability issue. So I think when Denny talks about no immediate reliability concern, a part of that is based on the fact that there are these mechanisms in place to help ensure reliability of the system in the case, you know, where you see all of these coal plants retiring. I don't think that there are an enormous number of those units, because they are being replaced with other units now, gas-fired as well as renewables, to the point where a lot of those units are being required to stay online to maintain reliability. So that's been part of the debate that's been going on, is, you know, show us the real problem here. Yes, there's a longer-term series of issues that need to be addressed. Let's do that as part of let's take our time and let's think these issues through. Let's not put a rule in place that could have significant impacts on the industry over the short term, where there is no short-term problem that's been demonstrated, at least not yet.
Do we have any other questions or follow-up on that? I think our power is still 4, right?
Exactly.
So I think we are there. We have time for one more question.
Sure. Mark James from Law School. So my question is about cost allocation. And I know you have a minute left to answer it, so that's plenty of time. So areas of MISO, areas of SPP are considered to be the Saudi Arabia of wind. And there's this idea of moving, you know, from generation to load, and that either requires transportation within MISO, out of MISO, from SPP across MISO to get to areas in the southeast or other areas that don't have, that are not having, where that load can be served. And you mentioned there are cost allocation issues, and so what are the processes for, you know, overcoming that, or working through some of the stakeholder processes, or working with state governments who don't see a benefit just to running a large HVDC line across their territory? You've got about 45 seconds.
The lightning round. Yeah.
Where to begin? We're just going through it. No, so we do have a stakeholder process, and we have cost allocation mechanism in place. It's just that when you start talking about renewables, the developers put in place their wind farms. The local TO says, why should I pay for a transmission to move your wind to the load when you're really benefiting from that? They're looking at it from that lens. And it becomes really challenging because at the end of the day, everybody is benefiting from it. The TO is benefiting from it because they get a rate of return on the transmission assets. So it's an ongoing process. When will it be resolved? Maybe the next 10 years I'll come back here and give you the answer on that. But it's really a complex issue. And discussions are happening at state level, at RTOs, and even at I would say at FERC level too. So, like that,
I was just going to say, at a high level, the principle is that the cost allocation should be assigned to the beneficiaries of the project, right? And so there are a variety of approved cost allocation mechanisms that are already in place under our tariff and under various other tariffs that say if it's this type of project, this is who benefits and they should be paid. If it's a project to relieve congestion, this is who the beneficiaries can be determined to be. If it's a reliability project, this is who the beneficiaries are and who should pay. If it's a multi-value project that's being built for public policy reasons, well then maybe everybody benefits and everybody should pay. Some of those underlying principles now are starting to be challenged because the wind project that is built in Iowa may be serving load in Chicago. So why should the people in Iowa pay for the generation that's moving to Chicago, or what portion should they pay? And then we have these inter-RTO debates going on now. If it's in SPP, but it's coming into MISO and transmission's needed, who should pay for that line? We're all having to deal with it right now, and it's a phenomenally complex issue, and then you start getting into the politics of it as well at the state commission levels who want to protect their customers from costs, and hopefully it won't take 10 years, but it'll seem like 10 years over the next year or two that we're talking about it.
And just to cap that off very briefly, I mean, there's really two different kinds of fights that you can have, or debates, I should probably say, rather than fights. And one is, you have the basic principles that have been agreed on for a long period of time, cost causation, beneficiary pays. And there are debates about, okay, are those rules still, appropriate? But a lot of it happens at a lot more the granular level in, the assumptions and in the how do you calculate the benefits. How do you calculate the costs, and what are the appropriate zones? So there's no great overriding answer to these problems. It's kind of just trying to take a set of core principles and apply them to come out with something that looks just as reasonable when applied to a given project or a given set of facts. My view, at least, is that's always going to be an evolving process. And it's one of the reasons why RTOs have robust stakeholder processes, so we can continually have these debates and refine those notions in response to new technology. I believe that we're out of time, but I just want to thank everyone for their questions, and especially thank Michael, Rush, and Benny for your time today.
Great. I hope everyone is caffeinated and ready to go here for the third and final session of the day. The next panel is impact of changing federal climate policy on electric vehicle adoption in the U.S. And I'm proud to introduce Thomas Ashley, JD, MSCL, class of 08.
Thanks, Dan. So just a quick note about kind of what we're starting to see. So first of all, my company, Greenlots, is in the electric vehicle charging space. The company makes software and sells that software along with its hardware that we built to a range of clients, including utilities, cities, and automakers. I think you all know, all of us know inherently that quickly or how slowly, and really how that's going to impact our daily lives. We're at a very interesting point in the development of this industry in that it's grown larger than ever before, but at least in this country, there's a lot of uncertainty facing the trajectory of the growth curve. And while a lot of that, which we won't get too much into it, I think, really has to do with the level of investment in the charging infrastructure itself. There's a lot happening here in DC right now that could significantly affect how we move forward in this industry. So we have a great group here to talk with you about their organizations and some of their thoughts on this. And I'm going to have them do some self-intros, talk about their organizations, why they're paying attention to this. And the this is a number of items. Joel will share a little bit more about some of them, but we are seeing activities at EPA, at DOT, at DOE, and maybe at IRS that will be affecting potentially how this market grows. So first we have Kellen Schefter from the Edison Electric Institute. Kellen, I think your current title is Manager of Sustainable Technologies. I think that has a primary focus on transportation electrification. Kellen unfortunately has to leave us a bit early, so please pardon his departure whenever that is. Next we have Elena Brady from NESCOM. I'm sure most of you are familiar, but it's the Northeast States for Coordinated Air Use Management, and happens to reside in Burlington, Vermont. And then we have Joel Bobase, who's a partner with Latham & Watkins, who's helping administer a new national coalition for advanced transportation. So Kellen, if you can just start off, tell us a little bit about your organization and why you're paying attention to this.
Sure. Thanks for that, Tom. And, thanks for having me here. Again, I do apologize for having to leave early. I think it's a good sign from my perspective because I was asked to speak on another panel on this topic later, and I'm encouraged that there's so much interest in this issue. So I always say yes to everything, and then I get in trouble with these kind of scheduling things. But I'm happy to talk about this at any length at any time, so I think it's a great topic. I'm with Edison Electric Institute. We are the trade association for all the investor-owned utilities in the U.S. So that's our membership. I work on sort of the customer solutions team, so we're interested in how people are using energy in new ways and that sort of thing, and how our companies can help enable that. So this transportation topic is a really big one, and when I think of it really big picture, you look at some like energy flow charts for how does our economy use energy, and transportation, the energy supply to transportation is 92% petroleum, right? I mean, when you look at transportation, it's an issue of petroleum generally in the U.S. Electric share of that is like 0.1%. We're not even in the 1% range yet. And so when we look at what are the opportunities for growth for more electric sales across the U.S., transportation is this big thing just sitting out there that we're not even really playing in yet. So that's a big opportunity that we see. But when we actually talk about that transition and getting from 0.1% to maybe 1% to maybe 5 or 10%, right? What's involved with that? And there's actually a lot of benefits involved. From a customer standpoint, electric transportation is generally more efficient, right? A motor is generally a more efficient way of converting energy to motion than an internal combustion engine is. That has a lot of benefits for the users when they have to pay for fuel, right? And today, if you charge your EV at home, for example, you're paying about $1 a gallon, $1.20 a gallon equivalent, right? And that's sort of this big customer benefit that we see. And if big fleets and buses and all these other big things convert to that, they'll see those savings too. That's kind of the customer side. From the societal standpoint, there's a big environmental benefit, obviously, and that's what a lot of us are interested in. The grid, the electric power sector, the sector that I represent, has seen a lot of actually decarbonization happening over the last few years. I think we're down 20% since 2005 levels or something like that. I get those numbers precisely wrong, but we've made some big improvements on the grid side. And actually just earlier last year, the transportation sector in the U.S. now actually surpassed the power sector in terms of the share of CO2 emissions in the U.S. So that's what we feel like is a big turning point, because we're making sort of this progress with more natural gas displacing coal and renewables coming on. Transportation is a little trickier situation because the cars get more efficient, but then people drive more when gas is cheaper and they switch in their sedan for an SUV or for a pickup, right? And so that's a little stickier situation. We would love to see more of that transportation sector move to the electric sector and kind of benefit from the progress we're making. So that's the big societal benefit. And then the other thing, just to why we're interested in this in particular for our companies, is there's a cool benefit that happens when you add this kind of load to the grid. It actually can make it all more efficient, right? So the cool thing with EVs is they could charge anywhere you're parked, essentially, right? And so you have this big opportunity where the cars can be charging. If that charging can happen in ways where the grid has extra capacity, right? You've already paid for and built the grid to serve a certain amount of load. If you can serve that EV load without having to add a lot of cost, you're actually making it more efficient, and that could put downward pressure on rates. So that's a sort of nuanced thing that is kind of just particular to our industry, but it helps give us a strong entry point to be talking about why we should be more proactive and engaged in this issue. So that's our big picture stuff. You know, we like this topic. We're really trying to go after it. I think why we're paying attention is you know, we're just now starting to see more of our companies take a more proactive role, thinking about how they can help build infrastructure to support this, how they can be more engaged with education and outreach. And we don't want to lose that momentum. I think sometimes some of the federal policy issues that Joel will get into more could sort of delay some of that. We could be talking about taking sort of our foot off the throttle, so to speak, and we don't want to see that. We'd like to kind of keep this momentum going. So we're focusing a lot more now on the states, I think, turning away from sort of the federal stuff. We've been looking at more of the state activity where our members can do more things, and we'd like to see that keep going. And so I'm happy to get more into details as we go, but that's kind of our big picture take on all this.
Sure, thanks, Kelly. And Elaine, are you a senior policy analyst?
Yes, senior policy advisor.
Advisor. Well, my apologies. Maybe you can just tell us a little bit about, for those of us who maybe aren't so familiar with NESCOM, what the organization is and how it's been involved in supporting transportation electrification to this point. And then we can maybe start thinking about what's going on or not going on in DC.
I'd be happy to, and thanks for having me today. I'm really pleased to be here. I've worked with a number of VLS grads over the years, and can say that VLS attorneys, many of them are some of my favorite attorneys, including my husband, who's a VLS grad. So glad to be here. So NESCOM, the Northeast States for Coordinated Air Use Management, is a nonprofit association of state clean air agencies in the Northeast, including New York, New Jersey, and the 6 New England states. It was founded by the governors of these states in 1967. Basically, NESCOM provides technical, policy, scientific, any other type of support to the clean air and climate programs in our states. And we often serve as a forum for multi-state collaboration. We find that our states sometimes can be more effective by working together, by pooling resources, sharing expertise. For instance, we can be more efficient and perhaps even more influential, because there's strength in numbers. So oftentimes we'll serve as this forum for multi-state collaboration, and a recent example of that is our multi-state zero-emission vehicle initiative. This started, it was 2013, 8 governors signed a memorandum of understanding to work together to implement their zero-emission vehicle programs and set a goal of 3.3 million zero-emission vehicles or electric cars on their roads by 2025, infrastructure to support those vehicles. Many of those states are the NESCOM states. We've got, let's see, Connecticut, Massachusetts, Rhode Island, Vermont, New York, as well as Maryland, Oregon, and California, that were what we call the ZMOU states. So we've been working collaboratively with them to basically put market-enabling actions in place, both individually as states and collectively. We've been working on things. I'll talk more about that later. So it's a really important topic to our states, and we're really watching what's happening at the federal level, because anything that's going to roll back emission standards and affect kind of our ability to address climate change is going to be something that's really, really important to us. And any threat to our state's right to adopt California's more stringent emission standards is something that our states are definitely going to keep a close eye on.
Joel, I wonder if you can just give us a little bit of your own background as you lead into maybe telling us a little bit more about current activity. And I think I'd appreciate if you could also share with us a little bit more about this coalition.
Great, happy to do it, Tom, and thanks very much for having me here. And I can echo the sentiments about VLS grads. Many of my colleagues over the years many of my beloved colleagues from over the years are grads. So it's a pleasure to be here. So I'm a partner at Latham & Watkins. Actually, my office is about a block and a half from here. We're for those of you who aren't familiar with Latham, it's the largest firm in the world by revenue. We have the largest environmental group in the U.S. So we're in over 30 offices in 22 countries or something like that. I'm in the Environment, Land, and Resources department here in D.C. I recently rejoined the firm. I actually started my legal career there about 10 years ago. Spent 4 years on the Hill working on energy and climate legislation there, and then 6 years at EPA, and then just recently returned to the firm following the end of the last administration. So I held a variety of roles at EPA, including leading the Office of Policy, but one of those roles was to help oversee the Mobile Sources program in the Office of Air and Radiation, where, of course, we worked on vehicle and fuel standards, among other things, including the greenhouse gas standards. That's I think part of what we're going to be talking about today. So one of the things that I've been working on since returning to Latham is we represent this ad hoc National Coalition for Advanced Transportation, which is it's a coalition of basically large investor-owned utilities. At this point, still investor-owned, although we will have some public utilities as well by the time we really get going. We have electric vehicle manufacturers as well as charging infrastructure manufacturers or companies that are involved in that space. And this group really came together primarily to engage on federal policy issues around vehicle standards. And I guess I'll be really brief here, and then we can get into more detail. But I think, from this set of companies' perspective, we're at a really interesting inflection point right now, where we have kind of this, I don't want to be dramatic by calling it a moment of crisis, but I think in the technical sense of the word crisis, it is, in the sense that you have this confluence of this technology and market inflection point, where we're really on the verge of a very significant transformation of our transportation system that relates to electric vehicles as well as autonomous vehicles and others on the one hand. And on the other hand, we're going through a fairly significant period of policy change, particularly here at the federal level, which can also affect what happens at the state level, that has the potential to affect, enhance, or adversely affect what's going on in the marketplace right now. So Kellen can speak, I think, more eloquently than I about what's going on in the marketplace. But we really are at this moment where, although the penetration levels of electric vehicles are relatively low at this moment in time, the rate of change is not dissimilar from what we've seen in other sort of spheres of market disruption in terms of where the technology is going. So you have the cost and availability and options and quality of options in terms of vehicles is changing dramatically. So really over the last 5 years, we've seen, so battery costs are the single largest component of an EV cost. That's come down by about 2/3 in the last 4 to 5 years, and is expected to go down by another 70% possibly within the next 5 years. And many market analysts are actually projecting that we'll reach a point of price parity between conventional internal combustion engine vehicles and electric vehicles without subsidies or incentives in the 2025 frame. At the same time, you have massive investments going on from the vehicle manufacturers, both dedicated companies like Tesla, as well as the major original equipment manufacturers, much of which is oriented towards other parts of the world, but of course will significantly affect what we have available here in the U.S. as well. So we've got 80 vehicles, that are I think we've got something like 30 plus models that are available now, and something in the range of 80 that are expected to be available have been announced and will be available within the next 3 to 5 years. So, you know, the range is extending considerably. Obviously, we have 2 new vehicles on the market this year in the kind of $35,000 range before incentives that, you know, have 200 plus, you know, mile range. So things are poised to change dramatically. We've seen some major policy announcements around the world around the transition away from internal combustion engine vehicles towards electric vehicles. So that's all happening on the one hand, and we're at a kind of an inflection point also with regard to the way that vehicle standards are functioning. But we've had this election, and so there's a policy discussion now going on about what are we going to do about these federal standards and state standards. So I won't dive into all the gory details about that, but until we get further in our discussion. But just to highlight, you know, so at the federal level, we have 2 sets of standards that are relevant here, right? We've got fuel economy standards that are implemented by DOT and NHTSA, the National Highway Traffic Safety Administration. Those are ostensibly harmonized with greenhouse gas emission standards under the Clean Air Act that EPA implements. We've had 2 rounds of light-duty vehicle standards. We've had 2 rounds of heavy-duty vehicle standards, and the current light-duty vehicle standards are the big focus. That's model years 2017 to 2025. And we're in a moment of re-looking at those because the DOT fuel economy standards haven't been done yet. They haven't been promulgated yet for model years 2022 to 2025, so they're in their process of getting ready to do that. The EPA standards are already in place, but the current administration is re-looking at the standards with a view to possibly relaxing them. Those standards don't require a lot of vehicle electrification, but at the margins, they certainly, the more stringent they are and the better incentives they include, the better, you know, the more push they help to provide for those vehicles. And then you've got this whole other world of state standards where you've got both greenhouse gas standards that have been adopted by 13 states, and then a ZEV mandate, zero emission vehicle mandate, which is a little bit more technology specific and a more specific push on EVs. It's been adopted by 10 states that together account for almost 30% of new vehicle sales in the US. And that program, the ZEV program, is about to go through a kind of a significant change where, because of the way that the crediting mechanism within the ZEV mandate works, the sort of effective stringency of that program is about to start to kind of ramp up in model years 2018 and beyond, and it's about to start to affect the non-California states in a bigger way. So this is the moment of crisis where, for those of you who are sort of students of history or worked in this space, in the second Bush administration, there were 2 kind of separate initiatives that happened to try to eliminate state authority to set these standards, and there's been a lot of conversation over the last 9 months or so about whether a similar move might be made in the current administration. So we've got this federal standard setting process that kind of affects things at the margins, and then we've got this kind of specter of potential risks to state authority. So our coalition is really organized to be active on those issues, and we'll look forward to talking more about that over the course of our conversation.
Thanks, Joel. Calvin, I think I'll hit you with some questions early on here. So, you know, we just heard, and those of us who see some of these items in the news, we know that auto companies are making some pretty significant investments in retooling manufacturing and developing new models, et cetera. Can you just talk to us a little bit about how the electric companies are thinking about supporting and making investments in this technology?
Sure. So, you know, as a first level, and I think as a baseline thing that our companies do is they make sure the grid is reliable and it works. And I think the posture that a lot of our companies had taken historically was, great, all these EVs will come, we'll serve that load just like any other load on the system. It'll be like air conditioning or whatever that happened in the 50s, 60s, 70s. Like as more electricity is needed, we'll build the grid to match that if it's needed. I think where we've seen the last few years, we've taken a more proactive approach. That's a little passive, right? That's sort of, if the load comes, great, we'll serve it. I think there's an opportunity that we've seen more and more companies explore this space where we look at the major barriers to making this happen and figure out how can we address those, right? So as a great example, when you look at like what is keeping consumers from adopting more EVs, right? The big ones are probably cost, and battery costs are coming down, and incentives can help kind of bridge that until we get to 2025 when they're completely cost parity. The other big one is education and awareness, right? If you poll people, most people still don't really know what an EV is or how it works, and I think our companies can make a big difference in helping education and outreach. They have touch points with all their customers. They could be doing, better job of educating their constituents. That gets into a little bit of an issue where sometimes we can't be seen as promoting electric over any other fuel, right? There's some fuel switching kind of de facto standards out there where we're not supposed to be promoting our fuel. But in this case, it's sort of an energy efficiency-like kind of program. So that's one opportunity. The big one that's kind of come from the last few years is charging infrastructure. That's sort of the next big barrier, right? If people perceive there's nowhere to charge these cars, or that it's not easy to get charging in their home, those kind of things. That's where I think we can help play an interesting role. Tom, you can talk more about some of the challenges on maybe the business models of getting charging infrastructure out there. But really quick, charging infrastructure, it takes a lot of capital to put a charging station somewhere in the world, right, at a business or in a sidewalk or whatever. And you don't get a lot of revenue necessarily from that. People will show up and charge and maybe pay a fee, but it's hard to recoup that capital investment through that infrastructure, right? So what we've seen our company start to do is actually say, how can we help extend our grid, assets out a little bit further so it helps cover some of that cost, take some of that cost off the customer, and then you get more infrastructure out there. We've seen the California investor-owned utilities really propose relatively big programs, over $1 billion now proposed to do this type of work. The rest of our members across the states haven't been as aggressive. California's always in a different situation, right? But we're starting to see this trend emerge where more and more of our companies are proposing these types of programs. So I think that's great. I think we can really help deploy our capital to help reduce a major barrier, which is charging infrastructure. The challenge always is, and there's a number of challenges, but it's sort of this phasing roadmap thing, right? You don't want to be doing this in a big way, build charging stations, and then the cars don't show up, right? We know that the automakers are investing in this long term. We know it's the trajectory long term. It's sort of in this weird transition period that we're in where, you don't know in the next, 2 to 3 years at what level they're going to really show up. And that can be challenging when you're trying to make these investments and convince your regulators, who our companies have to convince to do investment, that this is a prudent use of everybody's funding, right? So that's kind of the big challenge we're facing, kind of making that case why we think it's appropriate and why we're trying to plan for the long term. But it's sort of this blocking and tackling of the phasing, how much by when and where can get really challenging.
And just another question for you, Kellen. In terms of thinking about these investments, size, speed, et cetera, I think all of us understand that utilities planning processes can sometimes be slower than might be desirable, and there's a level of regulatory certainty that they're really seeking. Knowing that some of your membership, say in California, maybe is further along thinking about this and filing programs, deploying infrastructure than others in other parts of the country. What does it mean when there's a lot of policy, not necessarily regulatory, except in terms of vehicle standards, et cetera, uncertainty that's emanating not necessarily from their own commissions, which it may also be, but from here in DC?
Yeah, I think it's a great question. I mean, a lot of big industries say that certainty is the most important thing, and I think that's generally true. But I mean, I'll think back when there was the carbon cap and trade program being proposed in the House. Our organization actually was on board with that proposal, simply for that, I think that reason. Like, if we see this coming down the pipeline, let's be at the table when these negotiations happen. Same thing with the Clean Power Plan, which is now we've probably all discussed here. We'd like to be at the table and kind of have a roadmap and a path, right? On this topic, transportation, there is not really a great, federal program for electrification. We're sort of getting at it through these proxy situations with the federal fuel economy standards and then some of the states that have the ZEV program. We're not expecting, for example, a large infrastructure bill that would deploy a lot of charging stations or anything like that. We're not expecting that really to come down the pike. So in the interim, yeah, we're sort of left with this kind of patchwork of what's going on in the states. But it can be a really challenge. It's really hard to help really map out this roadmap so we can all be convinced of when we think things are happening and then when it's appropriate to invest and that kind of stuff. So yeah, that's why we've taken a lot more focus at the state level recently, where we know there are some states that have goals that they need to hit, and we can help states meet those goals. But yeah, at the federal level, it's a little trickier right now.
Thanks.
Yeah.
Elaine, you talked a little bit about how your organization works with the ZEV states, which, you know, all of this is based upon California's current authority to regulate vehicle emissions. Can you just talk to us a little bit about how big a deal this is if that authority goes away?
It's a really big deal for our states. 7 of the 8 NASCON states have the ZEV mandate. The other 3, obviously California, Maryland, and Oregon, we work closely with all of them. All of our states have set science-based greenhouse gas reduction goals. And they vary state to state, but they're on the order of 80% reduction from 1990 levels by 2050 or sooner. So keep that in mind on the one hand, and on the other hand, think about the fact that you already mentioned that greenhouse gases are transportation is the largest source of greenhouse gas emissions, around 40%. And so there's really no way to meet our state greenhouse gas reduction goals without transportation electrification. So, you know, transportation electrification and renewable energy figure prominently into all of our state climate action plans. So it's a really big deal. So that authority is taken away, and we're left with what the feds do. Historically, that's always been slower and less than California. There's times where the feds catch up with California, but California's always leading the way.
So maybe a follow-up question. You know, we're talking regulations that, you know, largely right now are applicable to non-electric vehicle manufacturers. Yes, they apply to them as well, but they're pretty good to go.
Yeah.
If we're talking about you know, a regulatory environment that encompasses sort of current or past transportation technologies and the companies that make those technologies, do you feel that the market could be moving fast enough and is big enough that a Tesla, BYD, maybe a renewed Fisker, and you know, maybe a Faraday, some of these companies, they're going to be able to produce and sell enough vehicles to support the state's activities?
It's possible. I mean, Tesla has the Model 3 coming out. You know, I think we're going to need a variety of vehicles. You know, from every price point, from minivans to, you know, compact cars to SUVs. So ideally, we'll see a lot, you know, more manufacturers involved, and really the traditional automakers, the ones that have been making conventional gasoline and diesel powered cars for years, they're investing billions of dollars. And if it wasn't for the Teslas and others, I mean, they probably wouldn't be moving as fast as they now are, and investing as much because they have to keep up. And the others sort of proving that it can be done, the technology's there. So I think we need them all in, and that's what the ZEV mandate, the zero emission vehicle mandate does. It basically requires all major automakers to sell increasing numbers of cars with zero emission vehicle technologies over the years. And so they're going to have to meet those standards. They're probably not I mean, the record showed it. The standards are not as aggressive as they could be, but you know, as you mentioned earlier, certainty is really important to industry. So people said, let's just stick with the standards that we set back in 2012. Even though the technology is advancing faster than we ever imagined, the battery costs are going down because we know that certainty is so important. So I think they'll be able to meet the standards.
Joel, maybe you can just talk us through a little bit, you know, just what from a process standpoint, what it would look like for this administration to indeed work to remove California's authority to regulate vehicle emissions?
Provide the secret roadmap. Well, I think there's two kind of buckets of issues that can affect the state standards, and we've seen the movie before, I guess, in the second Bush administration, so we at least have an idea of what the tools are in the toolbox, so to speak. So one piece is the waiver authority. So most of the folks in the room probably know that the Clean Air Act generally says states can't and local governments can't regulate emissions from new motor vehicles and engines, but California, when it does so and meets certain criteria, can but must receive a waiver of preemption from EPA under Section 209B of the Clean Air Act, and then if it does under Section 177 of the Act, anybody else in the other state can adopt the same California standards for which a waiver's been received. So in the second Bush administration, in the waning days of the administration in 2008, California had come to EPA seeking a waiver of preemption of the first round of the California state the PAVLI standards, the GHG standards for light-duty vehicles. And although EPA had never ever previously denied California a waiver request, and there have been, I think, something on the order of 50 such requests granted over the years since the enactment of the Act, the agency denied the waiver in that case with a fairly elaborately reasoned legal defense, and that was all teed up to be litigated in 2009, but then we had this election, and a new administration came in and reversed the policy and essentially rescinded the denial. So I think, from a process perspective, I guess the question is, well, where would that come up? There's no waiver request for light-duty vehicles, at least pending before the agency. Where would that come up? And there's a variety of potential scenarios that one could imagine. But one of the scenarios that's kind of brewing is California has said, we've done our midterm review of our standards, we're standing pat, we think our standards are feasible and appropriate, and we're going to go forward with those. And it's fairly clear at the federal level that the administration is planning to relax the standards. Right now, California's standards have a provision that's referred to as a deemed to comply provision, which is expressly mentioned in the 2013 waiver for these standards, and that provision lawyers will fight over what it means and its relevance here, so I'm not trying to give a definitive opinion, but it says basically if you comply with the federal standards, you'll be deemed to comply with the state standards. Well, what happens if the federal standards change? Will California continue to deem compliance with the federal standards to be compliance with the state standards? Will it change that provision? If it changes that provision, will its 2013 waiver still be effective, or will that open it up to challenges on that level? So that's one potential scenario. Of course, there's other future waiver requests depending on how long this administration goes, whether they have one term or two. There is a medium-term issue with regard to a heavy-duty waiver for Phase 2 California standards. So there's a variety of scenarios in which the waiver issue could come up. And then the second one it has to do with the CAFE statute, EPCA, the Energy Policy Conservation Act, which includes a preemption provision that says states can't do laws, standards, regulations relating to fuel economy or corporate average fuel economy standards. And so during the mid-2000s, when California did its first round of standards, those were challenged in Vermont, California, and I guess Rhode Island as well, as preempted under EPCA. The manufacturers and the dealers who brought those suits lost them at the district court level, but they were never litigated to the appellate level. So I think there's still some level of uncertainty around how the law turns out on those. But perhaps equally importantly, in a light-duty truck standard, a CAFE standard that NHTSA did in the later part of the administration, the NHTSA included a rather lengthy discussion of its view at the time under that administration that EPCO preempted California's standards. That regulation was struck down on other grounds, and again, we had this election and the new administration reversed course, so we never got to hear how the story kind of turns out. But again, that's another way in which you could see vulnerability, potential vulnerability for the state standards. The state will say, we're on very strong legal ground in both these regards, and I'm sure the NISCOM states would say the same, but those are areas in which that conflict could be teed up.
Elaine, we heard a little bit about the activities that many of your states are undertaking at a high level to support this market development. Are you able to tell us a little bit about how some of your states or your organization are really looking at and maybe preparing for potential evolution or de-evolution here in DC of some of these policies?
And Jill, I can speak from a general consensus of our states. I mean, our states basically supported EPA's determination in January that they should move forward with the standards through 2025 greenhouse gas standards, and strongly oppose the reconsideration of those standards now. And for the most part, we see this as just a complete waste of resources at the federal and the state level. A number of AGs from many of our states have already sent Pruitt a letter saying, we're going to defend these standards, take every appropriate legal action if they're weakened or delayed. And we have strong bipartisan support in the Northeast for, California's authority and our state's authority to adopt California standards. So they're not going to sit idly by if there are decisions that are not based on law and fact. So it's probably about as far as I can go.
Appreciate that. And Joel, I'll pose the same question to you. You're facilitating this new coalition, which is really came together to start working to maybe keep the status quo, in fact, to some extent. Can you talk to us, to the extent permissible, of just some of the activities that your coalition is engaged in or planning to be engaged in?
Sure, absolutely. And this is a group of leading businesses that really has skin in this game. And this is electric vehicles and advanced technology vehicles are a very important part of the business strategy of all the companies that are represented in our coalition. And so, this group wants and intends to participate constructively in the policy process that we're in at the federal level. Folks in the coalition, and we have a fair amount of experience in designing policies and creative mechanisms to provide market incentives and so forth. And so I think at the opening stages, we've been engaged with the agencies, meeting with them to share our perspectives, some of where our investments lie, where our expectations and interests lie in this process. We filed comments in each of the two sort of starting gun, requests for comments that have happened from the two agencies. We've met with the White House as well. And I think we'll plan to stay engaged. We're really just we're now at the kind of the crucial phase. I think that the policy direction of the administration is really likely to come together in a significant way over the next, several months to half a year. And so it's going to be really important for us to be in there and trying to share, constructive solutions that can be win-win solutions and will help to maintain the incentives that are so important to these companies.
Thank you. So we've been talking about a lot of, potentially bad news. But, Elaine, you talked a little bit about, the messaging that many of your governors have been providing the administration. And we all know that, whatever happens will be litigated. Can either of you maybe just share a little bit of your handicapping of, what length of process we might be looking at if this administration does act in a certain way.
Lengthy process. Like a lengthy legal battle. I mean.
Yeah, I mean, if just maybe from a process standpoint, not so much. Obviously,
I mean, I can offer some of the milestones apart from a regulatory perspective. You know, the ones that we kind of have a sense are going to happen, and I think EPA has said that it's going to issue a final determination in its midterm review. In other words, a determination as to whether the existing standards that are on the books from the last administration, quote unquote, remain appropriate under Section 202A of the Clean Air Act or not. So that proceeding, which had been closed at the end of the last administration, has been reopened, and that will be finalized by April 1 of 2018 is the projection. That's what's required by regulation, and so that's what they're aiming for. In terms of the overall, assuming that, well, NHTSA actually has a statutory obligation when it does fuel economy standards to finalize those at least 18 months before the commencement of the relevant model year, which dates from October 1. So if the agency has telegraphed that it might be thinking about changing the model year 2021 standards, which I think took a lot of people by surprise, but assuming that they stick with Plan A and leave the existing standards alone, that could potentially move the timeline back a little bit, at least for that year. Assuming they leave those alone, if they were just doing model year 2022 to 2025, that puts you having to finish those standards by April 1 of 2020. And so then you would have had to propose those probably a year or a year and a half in advance or so. So that kind of gives you the rough, idea of what the process might be like. We've got some interesting kind of interim, litigation that would follow. Let's say EPA and NHTSA in tandem do a joint rulemaking to redo, or do in NHTSA's case and redo in EPA's case the standards, and that wraps up in spring of 2020. That will tee up a multi-year litigation process starting in the DC circuit and then perhaps on from there. So a lot, as often is the case, and as we're witnessing now, a lot will depend on what happens in the November election in 2020 as to how that kind of story all turns out. So it's partly a litigation story and partly a political and election story. But here we have some interesting interim steps as well. The final determination that I mentioned, which might happen as early as spring of next year, is also a final agency action, so affords another potential opportunity for litigation. So it'll be interesting to see how it progresses.
Thanks. I'm going to step up to the lectern here and take some audience questions. I have plenty more for you, but I'd like to transition and turn to the audience a little bit before we wrap up.
Thanks, Alan. I am so befuddled by both the politics and the economics of this, of why electric vehicles aren't going faster. And I wonder about it at the political level, because it seems like, given the pricing, that it should be an obvious direction that many consumers want to go, not just the tech geeks. And from a political standpoint, I would think that that's not a partisan issue. That's, how do we serve our customers, or our consumers, our constituents as consumers? And that leads me then, and I also think from the industry standpoint, I would assume that the industry would also be thinking intensely about the consumers and what they want and want to move to, putting aside climate just from a kind of an economic standpoint. So a question for any of you is just, what policies can the states do that will help incentivize or encourage or educate, facilitate communications between the people who want to sell this technology to consumers?
As I mentioned earlier, we're working with the multi-state 7 initiative on a number of market-enabling actions. And so at the state level, one of the most important things states can do are offer incentives beyond the federal incentives. We're also working collaboratively on a consumer awareness campaign Because, although you know all the great benefits of electric vehicles, most people don't. It's just when it comes time for them to buy a car, electric vehicles aren't even on the short list of cars they're thinking about, so they're just not even considering them. So our states basically have been working with the major automakers to develop and launch a brand neutral campaign that will, hopefully increase consideration and awareness of electric vehicles. We hope to launch that early in 2018. So we have 16 major automakers signed up to partner with us on that, and along with the Northeast states, we'll be focusing in that area first. There's a number of other things. We talked a little about utilities before. We really need utilities to be investing more in transportation electrification. So NESCOM, along with our states, has been holding a number of workshops to help to move the Northeast utilities in that direction. In 2016, we had a workshop for environmental and energy regulators with major utilities in the Northeast to talk about the environmental and electric grid and ratepayer benefits of transportation electrification. Last year, we held a workshop for PUC commissioners to talk more about the benefits of widespread transportation electrification for utilities and ratepayers. And now we're thinking about holding a workshop for ratepayer advocates, who are kind of a major stakeholder in these proceedings. And we're starting to see some movement in this. There's now, I think, EV-related PUC proceedings in 5 states in the Northeast and Mid-Atlantic, and a couple more that kind of have these broad, like Vermont just opened a proceeding to relook at how they regulate electricity, and electric vehicles may or may not be part of that discussion, but that's a big thing that states can do. Other things, exemptions for electric vehicles, for instance, in HOV lanes, bridges and tolls, having government officials, basically, drive these, talk about them, make it more the norm, send out these strong signals for consumers is a great thing too. I could go on.
Well, I'm going to actually add to that. So, just at a very, very mechanical level, right now the structure of how autos sell vehicles primarily goes through dealers. The dealer lobby happens to be one of the strongest, best connected lobbies at the state level. And so, Tesla, which does not have a dealer model, has a showcase model, but it's really an online ordering process. That company basically is still, going through a fight in a number of states to be able to sell its vehicle direct to consumers in that state and not have to go through this dealer model. And fundamentally, right now, one of the greatest challenges with dealers is they're not motivated to sell these vehicles. As some of you may know, the business model for auto dealerships is really built around service, not sales. So the margin that dealers take on the sale of the vehicles in terms of the percentage of overall revenue is much lower than the margin that you get on servicing those vehicles that they sold. And so these are vehicles that frankly require very little service. And so you're effectively talking about trying to have an entity undermine its own business model. And fundamentally, until we decide how to either evolve that dealer business model or regulate it differently, we're going to have this fundamental challenge of how to get those vehicles to consumers in a way that they then know about and can get excited about the technology.
So, Michael Kessler again. I learned the other day that there was an MIT study, I think, that showed that 90% of travel can generally be covered with the range of today's electric vehicles. and yet consumers still have this whole range envy syndrome. And I know even as I'm looking for a new car, and we have charging stations at work, I'm still looking at a hybrid because I can't afford a Tesla S and I didn't sign up for the E, and so it's going to be a ways out there. So I guess my question is, where do gas electric hybrids sort of fit in? Is it a short-term transition to an all-electric fleet, or I've seen like Volvo has announced that they're transitioning their entire fleet over to electric in the early 20s, but right now hybrid is sort of the transition vehicle there. So I'm curious about your thoughts on that.
Sure. So there's the conventional hybrids, like the Toyota Prius that everyone's familiar with. And then there's the plug-in hybrid, which you basically plug in and you get somewhere between 20 and 60 miles electric range, and then it switches over to gasoline. And then there's the all-electric vehicles. So the plug-in hybrid and the all-electric vehicles are both covered by the zero-emission vehicle mandate. And we, I think basically the climate plans in California as well as our states take both into consideration, being as viable options, recognizing that maybe an all-battery electric vehicle right now might not be the best option for everyone. So I think you got to figure out what's going to work best for you and your lifestyle. But although 90% of travel is fine with the electric vehicle, people always think, well, maybe I want to drive cross country and pull boat, so you can't get that car. I would suggest maybe rent a car when you take that trip. But there's all different kinds of flavors of electric vehicles, so hopefully people find some awareness that there's one that suits their lifestyle.
And I'll maybe add as well. I really think about not hybrids, but plug-in hybrids as the gateway drug, right? It's the way you get to that different lifestyle. And it happens that the average driver drives about 40 miles a day, and that is covered by even the smallest full battery electric vehicle on the market in the US right now. But we as consumers, especially in this country, we have a different psychology about travel, transportation, freedom, personal choice, and I don't know what the stats are, but there are stats that indicate that we are making decisions based on the 2% of times that we do this or that. And so there's a lot of really irrational economic buying behavior occurring right now, which we're starting to see in an urban environment take a different tone as we're starting to use more car ride sharing. And that's a much more maybe economically rational behavior because we're paying for the mobility that we need. We're not paying for the mobility that we don't need or aren't using. But this is not going away anytime soon in terms of the decision-making process. Michelle.
Unfortunately, I'm not here for this, but maybe Tom can help with your experience in California. I think, given the challenge of the states to provide funding for incentives and things like that, I think utilities are really the answer here. And I know from observing what's happening in California, at first the state government was kind of hesitant to allow the utilities to build up the infrastructure, and I think now they're seeing that they clearly have to be a part of it. But also because of the things that we can do in terms of increased utilization of the electric system, getting people to charge off peak, can actually bring rates down and save people money, that there's a lot of ability for the utilities to actually not only fund the charging infrastructure, but provide the incentives that are going to get people to do this. And I wonder if you can maybe talk a little bit about your experience we've seen in California, whether there's some emerging strategies to make that happen, because I'm not seeing it happen elsewhere. The utilities aren't being as aggressive as you think they would be on this, given it's really helps their bottom line.
So I really travel the country in North America, engaging in this policy regulatory discussion, sometimes formally, sometimes not so formally. And whenever I'm somewhere other than California and I mention California, you know, everyone either rolls their eyes or, you know, tunes out. And so, you know, what happens in California doesn't necessarily stay in California, but it's not necessarily a model that other states are looking to follow to the T. But even in California, with all of the enabling policies in place, fundamentally the Public Utilities Commission had to pretty much come to a determination of market failure of private investment in this space to even think about letting the utilities come to the table with something. You know, fast forward, we've seen a lot of policy and regulatory evolution in California since then. But this is an incredibly challenging regulatory endeavor, really for all involved. You know, yes, the utilities want certainty. Utilities are just trying to figure this out from a technology, operations, grid modernization standpoint. And, you know, that process is ongoing at every utility, including the California utilities. But then you also have an unknown or uncertain regulatory environment. You know, this is technology, this is a way of thinking and potentially regulating that most commissions simply haven't done. And so I'm not trying to throw too much cold water on you, but one of the challenges that we've really seen is that the types of true benefits to all ratepayers, those accrue at scale. And even in California, we're not even close to the scale where those numbers clearly work every time, all the time. And you know, the commissions, the utilities themselves, and certainly the commissions, they're not ready for the scale of program filings or potential ratepayer investment that the utilities are starting to would need to come to the table with to be able to check all those boxes every time. And so I don't have a good answer. There is not a clear precedent that is being translated outside of California. Even precedent within California is still very much evolving as the utilities, as the commission, you know, sometimes a little bit arbitrarily has been forcing utilities into different program designs. So there's huge benefit. I mean, this is load growth, this is a more efficient grid, this is integrating renewables, it's doing everything that a utility or grid operator could possibly want, but it's not doing it until there's a certain scale. And so we talk, in this industry, we talk a lot about chicken and egg, charging infrastructure versus vehicles on the road. And what we're really seeing in the regulatory environment is a different sort of chicken and egg situation, which is, you know, show us why these benefits accrue to all ratepayers, such that we should approve these programs. Yet the utilities really, they need more certainty before they're even willing to do that at a modest scale, let alone the scale that's really needed to show these things.
Just maybe a quick follow-up. To me, the interesting part is just kind of the reverse of what's happening with solar, where the utilities, you know, are beginning to push back on solar big time because they see as more of it comes on the system has negative rate impacts. And this is really the opposite. To the extent you can incent this can offset some of the impacts that solar's having and support that. And so I guess it's kind of frustrating to not see the forward-looking policy when it seems so clear.
It is. I don't have any secret sauce here. The ability that this technology and utilities, if they're able to manage this technology, it really is through the roof and helps us accomplish so many other things in the energy, electricity, and the transportation space. But it's just slow moving. And you know, we are starting to see some other jurisdictions, Washington State, for example, take what I would say is a more forward-looking approach, which is more about accelerating this market, not necessarily about what the balance sheet looks like. But we're seeing. I just got word earlier today in DC that Pepco's very modest filing here for just really a small number and a few million in investment in charging infrastructure just got rolled into kind of the grid mod process, which is going to slow down. And so we're seeing that all over the place.
Hi, Tom. Tom McHenry. I'm the new dean at Vermont Law School. Delighted to be so, but I did live in Southern California for 30 years, and it sounds like this discussion is partially a discussion about hearts and minds. And I wonder if you spend any time talking to the entertainment industry about this and the leadership they might be able to take. Because what you're saying is that people aren't driving electric vehicles because they don't think it's cool or appropriate to drive electric vehicles, but what drives what Americans do is popular culture. If the Nest Facts and Furious movie was made entirely with electric vehicles, you get a lot more market penetration. But I just, there's the Environmental Management Association in Hollywood, and whatever your feelings are about the whole Hollywood world, that's a place to spend a little time. They certainly have that interest, and whether you could get some penetration would be an interesting project.
Yeah, no, I agree. I myself have not engaged in the entertainment industry on this topic, but I'll give a little personal anecdote. When I really decided to jump into this industry, I moved to Palo Alto, and that's Tesla's headquarters. I felt it was the epicenter of the electric vehicle industry, not just in this country, but the world. And then with my present company, I was asked to move to LA, which did not seem to be that epicenter. But I moved and discovered that it was, in fact. And so in LA, it happens that the sales of Teslas outpace every other. I don't know what the numbers are, but at least anecdotally, the sales of Tesla seem to outpace every other vehicle in that buying class. And I just look across the street sometimes or in the next lane over, and often people behind the wheel are in fact in the entertainment industry.
That's true nationally, by the way. The Model S is the leading luxury sedan. And so people who can afford them,
But I think that what we're not seeing is the souped-up electric F-150 or Chevy Tahoe. We're not seeing lower, less expensive electric vehicles that people do think are cool. I think they are. And so, the cool factor is very significant, but because that largely seems to rest right now around Tesla, which is often at a price point that does not seem relevant to a lot of the buying public, there's sort of an attainability factor that makes this technology sometimes seem less accessible or less relevant to the daily life of Joe Schmo car buyer than necessarily if we were seeing that F-150 or something else that really did not just appeal to, but had a lot more relevance to the daily life activities of the larger buying majority.
Can I just make one quick comment on that? I think this is it's like a necessary part of our future. We have to do what you're doing, and I think we all have to do it. Like not only just do it for ourselves, but talk about it with everyone we know that you've got to switch to electric cars. I mean, it has to happen. I mean, if you're going to save 2 degrees, which is what I want to do, we got to do this as a country.
Are there other questions?
So we actually, sorry, we have to transition
please join me in a round of applause for our panelists.